Chief Justice and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the Court is now in session.
The Madam Clerk of Court will please call the matter at hand.
Called for today's oral argument is the continuation of the hearing in the RH law cases. Appearing as counsels for petitioners in GR number 204819 and 207111 are the following: Attorney James Imbong, Attorney Joe Aurea Imbong. Appearing as counsels for GR number 204934 are the following: Attorney Maria Concepcion Noche, Attorney Fides Angeli Sabio. Appearing as counsel for petitioners in GR number 204957 is Attorney Makilito Mahinay. Appearing as counsel for petitioners in GR number 205478 is Attorney Howard M. Calleja. Appearing as counsels for petitioner in GR number 205491 are the following: Honorable Francisco Estatad and Attorney Alan Pagia. Appearing as counsels for petitioner in GR number 207563 is Attorney Luis Maria Hill Gana. Appearing as counsel for respondents are the following: Honorable Edsel Silagman. For the Solicitor General Francis Hardilesa, Assistant Solicitor General Hermes Ocampo, Assistant Solicitor General Mirna N. Agno Canuto, Assistant Solicitor General Derek Bertoliano, Senior State Solicitor Florin Hilbay, State Solicitor Maria Sofia Obieta Palad, Associate Solicitor Denise D. Flores, Associate Solicitor Christian Louis Gonzalez, Associate Solicitor Emerson S. Bañez, Associate Solicitor Maria Cristina T. Navarro, Associate Solicitor Isa Katrina San Jose Valdez, Associate Solicitor Maximo Paulino Sison, Associate Solicitor Leanne Maureen Apolinar. Appearing as counsel for intervenors Cabral et al. And Senator Pilar Juliano S. Cayetano are Honorable Pilar Juliano Cayetano herself and Attorney Elizabeth Aguiling Pangalangan and Attorney Herminio Jare L. Roque. Appearing as counsel for intervenors De Venecia et al. Are Attorney E.M. Lombos. Appearing as counsels for Catholics for RH are Attorney Clara Rita Padilla, Attorney Marlon Manuel, and Attorney Ray Paulo Santiago. To argue today are the following: Attorney Luis Gana for 5 minutes, the Solicitor General Francis H. Hardilesa for 40 minutes, Congressman Edsel Lagman for 13 minutes, Senator Pia Cayetano for 13 minutes, and Senior State Solicitor Florin Hilbay for 15 minutes.
Counsel for petitioners may please take their seats. Counsel for respondents, let me just clarify. Solgen Hardilesa, you will discuss right to life in general.
Yes, Chief Justice.
With care to make sure that you do not try to repeat or preempt the discussion of your other counsel for respondents.
Yes, we will do, Madam Chief Justice.
Congressman Lagman will talk about legislative intent. Senator Cayetano will talk about maternal health and right to health. And then Senior State Solicitor Hilbay will talk about quite a lot: freedom of speech and religion, academic freedom, and local government.
Yes, Madam
Okay.
Chief Justice.
So after you have confirmed your agreement, we will proceed first with the presentation of Attorney Gana. Please take your seats.
Your Honors, good afternoon. RA 10354 is a national policy program on reproductive health that directs all LGUs to participate in said program without any qualification as to the exclusion of the ARM or the LGUs in the ARM from its coverage. Neither does the IRR of RA 10354 make such exclusion. Mindful of the statement of the Court that the autonomy granted to the ARM cannot be invoked to defeat national policies and concerns, petitioners, however, contend that the implementation of this particular law in the ARM will violate the ARM's regional autonomy on two fronts, under RA 9054 and under Section 20, Article 10 of the Constitution. On the first ground, RA 9054, the ARM or Organic Act of 2001. This was enacted under Section 15, Article 10 of the Constitution to create an autonomous region consisting of LGUs sharing common and distinctive historical and cultural heritage, among others. Section 3, Article 4 of RA 9054 grants the Regional Assembly legislative powers in the ARM, except on certain enumerated powers that have been reserved for the national government. Accordingly, if the power was not among those enumerated as reserved for the national government, then such power belongs to the Regional Assembly. Legislation over health concerns was not among those enumerated powers reserved for the national government. So that on December 13, 2012, the ARM Regional Assembly passed its own version of the RH law, Muslim Mindanao Autonomy Act number 292. Admittedly, a perusal of the ARM's RH law will show similar features to RA 10354, particularly on the sections mentioned in the advisory. But the difference lies not only in the details, but more so in the guiding principles of ARM's RH law that sets it apart from RA 10354. Under the ARM's RH law, the first guiding principle is the promotion of natural family planning method. The second guiding principle is the guarantee of freedom of information on artificial planning methods among legally married couples. It also provides for the regional government to consider all natural and medically safe and legal modern family planning methods not only approved by the WHO and FDA, but more importantly also approved by the Assembly of the Darul Ifta of the Philippines, their Council of Elders. From these guiding principles, you can see the sharp contrast of ARM's RH law with RA 10354. 1. The ARM's RH law definition of reproductive health does not include a woman's right to sexual health, that is, of having a safe and satisfying sex life, because the ARM RH law discourages premarital sex and does not, as a policy, distribute contraceptives to single adults unless prescribed by a doctor. 2. The ARM RH law cannot provide for a full range of family planning supplies and services because its regional government will disallow sterilization as well as hormonal contraceptives that inhibit a woman's lactation within 2 years of childbirth. 3. The ARM RH law does not, by legal fiat, categorize hormonal contraceptives, IUDs, and injectables as universally safe and as non-abortive fashions, considering that medical studies and statements showing the same to have already the effect of preventing the implantation of a fertilized egg in the uterus, and that the FDA's existing practice of accepting as proven safe any family planning products procured from UNICEF, UNDP, WHO, GDF, and UNFPA pursuant to Department of Health Administrative Order 11 of 2012 that exempts these products from securing an FDA certificate of product registration, notwithstanding that these international agencies are all known pro-abortion advocates that consider pregnancy to begin after implantation, and thus to them, anything that prevents implantation is but a contraceptive. Fortunately, the ARM RH law provides a window of opportunity through the Darul Ifta for pro-life advocates to counter these wrong notions being peddled by these international agencies. Clearly, the implementation of RA 10354 in the territory of the ARM would run counter to the ARM's power as an autonomous region to pass a health legislation that is in harmony with its tradition and cultural beliefs. On the second ground, Section 20, Article 10 of the Constitution, we submit that the implementation of such a national policy program in the ARM would run afoul of this provision. The Court has explained that Section 20 provides the restriction on the power of Congress to pass legislation on areas already devolved to the ARM. Among the subjects of legislation enumerated in Section 20 that are devolved to the autonomous regions are personal and family relations and social development. A RH law that educates and promotes the right of women to have access to family planning methods would fall under the subject matter of persons and family relations. A RH law that provides healthcare supplies and services, especially to the marginalized members of society, is part and parcel of any social development program. Accordingly, a RH law to be implemented in the ARM can only be one passed by its regional assembly. To end, allow me to quote the favorite passage of petitioner Al-Marin Tila from the Quran. If anyone killed a person, not in retaliation of murder, or to spread mischief in the land, it would be as if he killed all mankind. And if anyone saved a life, it would be as if he saved the life of all mankind. In the words of petitioner, Islam teaches that life is precious and given by God, and procreation and the blessings of children are seen by Muslims as a natural consequence of married life. Islam can be said to be pro-life, and any action that preserves, prolongs, and protects life is encouraged on condition that it conforms to the moral and ethical teachings of Islam as defined within the Quran and the Sharia. Thank you, Your Honor.
Justice Mendoza.
Attorney Gana, you mentioned about matters already devolved to the ARMM.
Yes, Your Honor, under the Council.
Is it your position that the national government cannot pass any law affecting what these matters devolved to the ARMM, like those relating to health, social services, education?
Your Honor, in Kida versus Senate, as well as in Disolan Corp versus DPWH, the court had the opportunity to explain that Section 20 of Article 10 of the Constitution provides a limitation on Congress to pass national legislation for implementation on ARM on matters that have already been devolved, which is consistent with their political autonomy.
If the national government passes such a law, is this, you mean to say that this should be subjected to another plebiscite?
Well,
it is in your petition, the petition of...
Well, yes, Your Honor. If, based on the majority opinion in Kida versus Senate of 8 justices, they said that if any law is to be passed that amends three items, the administrative organization of the ARM, the jurisdiction of the Sharia courts, as well as the areas of legislation, then it must be subject to a plebiscite.
I see. Is the principle of... you are also covering the LGU, the matter of the LGUs.
I beg your pardon?
The LGUs.
Yes, Your Honor. We're talking about the LGUs.
Is the principle of the local autonomy violated when the national government enacts laws on matters relating to maternal and child care or purchase of medicines?
Precisely, Your Honor. It is our position that health care, especially this in terms of maternal and infant health care, would fall under the provisions of the devolved powers of personal and family relations as well as social development programs. In addition, under RA 90, I'm sorry if I may continue.
Yes,
in addition, under 9054, it says that only the powers, except for the powers reserved for the national government, all of it devolves to the ARM. Regional government.
The national government cannot, I'm speaking about the LGUs, so the national government cannot enact laws giving assistance to the local government on these matters?
Well, the national government can always give assistance in any way. in a similar way that the Department of Health under its GAA has provisions for support for the autonomous regions. It has a budget in its GAA for support for projects. But to pass laws to be implemented in the ARM on areas that belong solely to the devolved functions of the ARM regional government, then it cannot.
So your position is that the LGU is the sole or exclusive agency to enact such laws.
The regional government of the ARM.
Government, yes.
Because the regional government also has its own its ARM local government code.
That's all, Chief.
Justice Leonen.
Good afternoon, Counsel.
Good afternoon.
Good afternoon, Counsel. Let me just look at the relief that you are praying for in terms of the petition that you are representing or the petitioners that you are representing. What, in effect, is the relief that you're asking?
We're simply asking for prohibition to prevent the implementation of RA 10354 in the ARM.
Not to declare the law as unconstitutional or illegal because it affects the ARM.
We are simply saying that the ARM has its own RH law pursuant to its political autonomy. So our petition is limited in scope. It is not within the function. It is not within the purposes of the petitioner to. And we leave it to the other petitioners to question the constitutionality of RA 10354 per se. But ours is simply as applied to ARM.
So, in theory, your own petition can be separated from the rest because the grounds that you're raising is completely different. Is that not correct?
Technically, I was surprised why I was included in the oral arguments.
Oh, so you were as surprised as your petitioners. Also, may I ask, has there been relief in the ARM regarding an incident or a situation relating to this?
Well, Your Honor, the RH law was passed, the ARM RH law was passed in December of 2012. Its implementing rules have not yet been finalized by the Secretary of Health of the
so
DOH.
So you filed your petition prior to the issuance of the implementing rules and regulations?
We filed this petition simply because the RA 10354 is very all-encompassing.
No, Counsel, I'm looking at the timing of your
Yes, we timed it. In other words, we did not wait.
We
did not wait for any we did not wait for any memorandum from Secretary Ona to be passed on. We did not wait for any incident. In short, we jumped the gun simply because we saw the law on its face.
By jumping the gun, can we say that this is premature?
Well, Your Honor, we are aware of that argument, but we maintain that the law itself, on its face, as applied, is all-encompassing.
There is no need for the position of the ARMM on your petition.
The position of the ARM is that they believe that their ARM version will stand.
I mean, are they petitioners in this case?
No, they're not.
Have you impleaded them as respondents?
No, Your Honor.
So how are we supposed to know the official position of the ARMM in this case?
Well, ours simply our
In other
position.
words, Counsel, shouldn't they have been impleaded in this action?
Your Honor, as far as the petitioner is concerned, regardless of his personal views on reproductive health, as an advocate for regional autonomy, he is prepared to fight tooth and nail to protect any law passed by the ARM.
Yeah, I understand that. But the question is, shouldn't the ARMM have been impleaded as an indispensable party to your petition?
We submit no, Your Honor.
Why?
We submit that the law itself, that is all-encompassing and including all local governments, regardless of where situated, to comply with RA 10354, is on its face already violative of the autonomy granted to the ARM. That is the position adopted by petitioner. We did not feel that we had to wait for a specific instance when the Secretary Ona would direct.
No, Counsel, my question was not relating to whether there's an actual controversy. We've traversed that already. You stated your position on that. The question really is whether the ARM should have been impleaded as an indispensable party, and you say that no, because...
Well, it's not indispensable in the sense that the court can pronounce judgment even without their presence.
What about the interpretation of their MMA 280 and 292? Are we sure that their interpretation in terms of implementation will be or must be the same as ours?
Well, that's why, Your Honor, from the law...
Because you said that in terms of some of the provisions, there is advertence to the Darul Ifta. Is that not correct?
Yes, Your Honor.
And the Darul Ifta is not this court, correct?
Yes, Your Honor.
By the way, what is the Darul Ifta?
It is like their Council of Elders, their House of Opinion.
No, I'm
It is
sorry, I don't think that there is a council of elders.
Well, it is a collegial body,
collegial
of Islamic scholars and Muslim leaders who give Islamic rulings on certain social, political, family, and other matters.
Yes, on Islamic law. Is that not correct?
Yes, Your Honor.
And they issue a fatwa. Is that not right?
Yes, Your Honor.
What is a fatwa?
Is there Islamic ruling?
An Islamic ruling, or is it an opinion of the Islamic scholars who are respected in the area?
Well, that I would concede to your version, Your Honor.
Yes, and because it is a bit complicated as to know what a valid fatwa is, insofar as we are concerned, then therefore I think that the ARMM should have been implemented. Is that not correct? By the way, what is a valid fatwa in terms of Sharia?
Well, Your Honor, as I was made to understand, particularly in this case, in 2004 there was a fatwa issued with regard to reproductive health. It was issued in the...
No, I'm just asking about the validity of a fatwa. Let's go through it part by part,
okay,
so that we are able to understand it and understand the question as to whether the ARM should have been implemented as an indispensable party. What is a valid fatwa, counsel? Since you raised it in your oral arguments.
Well, this, to our mind, to our understanding, a valid fatwa would be one that was issued by the collegial body in terms of a specific issue being raised.
Of course, the fact that it is consensual and the broader the ulama and the mufti that are involved, the better for the strength of that fatwa.
Yes, Your Honor.
But can you tell us if there is a hierarchy of norms that will tend to show whether a fatwa is valid or not?
I'm not qualified on that matter, Your Honor.
Yes. Precisely, again, shouldn't the ARM have been implemented as a party to this case so as to clarify whether the interpretation of this court, or perhaps your interpretation as petitioners, would be the same as that of the ARM and that of national law is not a problem, but with the MMAA, which does, as you said, provide in its provisions the consultation with the Darul Ifta?
Well, Your Honor, it is when we filed this petition, it is our position that there was no need to implead the ARM as a party, as an indispensable party. It was our position that simply based on the law, RA 10354, based on the Constitution, based on RA 9054, that it was sufficient that petitioner, as a constituent of the ARM, would be able to
argue
upstand
the autonomy of the ARM. Is that not correct?
Yes, Your Honor.
And part of the autonomy of the ARM is that it has a distinctive cultural, historical characteristic. Is that not correct?
Yes, Your Honor.
Shouldn't the court respect that by allowing the ARM to also plead in cases like this and not arrogate simply upon itself its interpretation of things like Darul Ifta, Fatwa, Mufti, and all of this?
Well, Your Honor, if the court were to invite...
For instance, counsel, you mentioned 2 years of lactation. This is in what fatwa?
Well, this was given. Well, this was based on my communications with the author of the RH bill.
In other words, when
I talked with Assemblywoman Arin Tila regarding what contraceptives would be...
Can you explain to us the context of 2 years of lactation, which is part of the Quran, of course, into the interpretation of the Grand Mufti and the fatwa issued in 2003 as well as the one issued in 2012?
Well, Your Honor, I will be first to admit that I am not an expert on that.
But you did mention 2 years
Yes, I mentioned it precisely because in my discussions with the Assemblywoman Tila, he explained to us that precisely contraceptives that affect the lactation of a mother within 2 years is not acceptable to them because it prejudices the child.
You mean, counsel, we are speaking for them, but we do not know what their Sharia is? In terms of the question that I'm asking now, which you raised in your oral arguments, do you want us to speculate and therefore do a disservice for the peoples that are represented?
Well, Your Honor...
Again, shouldn't we have implemented the ARM?
Your Honor, without trying to be argumentative, as we mentioned our position, And we have no objection if this court were to invite as an amicus curiae.
As a
the
matter
regional
of
government.
fact, in terms of the fatwa issued in 2003, I think it was read by the Grand Mufti himself, Sheikh Pasigan, in Davao, correct?
Yes.
That they said that contraception was all right. Isn't that correct?
Yes, Your Honor.
Yes. And then it was again succeeded by another fatwa in 2012 upon the request of the DOH. Again, they said that it was all right to have concepts like reproductive health and family planning. Is that not correct?
Yes, Your Honor.
And it is not entirely accurate that in Islam, that artificial contraception is prohibited. Is that not correct?
Your Honor, we never said it was. In fact, as you mentioned,
in
the
your
2000...
oral argument, you said that the bias is towards natural family planning. Is that
Well, I
not
am just
correct?
reading the first guiding principle.
So-
they were in MMA 292.
Yes,
And it
but
does
also in
recognize...
MMA 292, there is also advertence for purposes of certifying which contraceptives are legal, not only the FDA, but also the Darul Ifta. Is that not correct?
Yes, Your Honor.
And of course, the Darul Ifta includes the fatwa. Is that
Yes,
not
Your
correct?
Honor.
Yes. And therefore, it is not true that it is only natural contraception which is allowed, correct?
Your Honor, I never said it was the only one. As I mentioned in our oral
By the
arguments.
way, would you know the basis in terms of the fatwa? The basis in the hadith or in the Quran? Of
No,
why contraception is there?
Well, as I understood it, they mentioned that they said that there's nothing in the Quran that prohibits contraception.
Yes, but that is not all. It was a very well-argued fatwa. It was deeply rooted not only in the Quran, but also in the hadith. And in fact, in the Sunnah. Is that not correct?
Well, I am not in a position
Again,
to...
the question is, when we rule on this matter, shouldn't we first have the ARMM first have a ruling on this or an implementation before it goes up to the Supreme Court?
As far as the petitioner is concerned, that's to be repetitive. I'm sorry to be repetitive, given your position you've taken. When we filed this petition, it was the belief
I have
of...
not taken a position.
No, in
These
terms
are
of
just
your
questions. Yes.
statement, Your Honor, of which I'm supposed to respond
These are
to.
not statements, these are questions.
Your questions. Our position really, Your Honor, for the petitioner was that we felt it was sufficient, based on the law, based on the Constitution, to file this petition.
By the way, Counsel, your petitioners are
Altila and Professor Kashim.
females? Males.
Males.
Do you have a petitioner who is a woman, Muslim?
None, Your Honor. Just two male petitioners.
Just two.
Two.
To represent.
Well, they're representing their interests as constituents of the arm.
By the way, is it Islamic for only one person to represent the Ummah?
They're representing their own interests as citizens.
As citizens, okay.
As residents of ARM. Because particularly for Petitioner Altila, who is an advocate for regional autonomy.
Yes. Yes, I know Petitioner Tila very well, and I know his contribution to the movement to gain autonomy for the area, and I highly respect that. But again, the petitioners were only two males. Is that not correct?
Yes, Your Honor.
Yes. Section 20 of Article 10, do you have a copy of that?
Of the RA 10354.
No, of the Constitution.
I'm sorry.
Section 20 of the Constitution.
Yes, Your Honor.
Can you please read the chapeau or the opening paragraph?
Wait, Your Honor. Wait, Your Honor. Let me just... Okay, here. Wait, I'm so... Oh, wait.
Within its territorial jurisdiction.
Yes, Your Honor.
Yes.
Where is that?
Within its territorial jurisdiction and subject to the provisions of this Constitution
Yes, Your Honor.
and national laws, the Organic Act of Autonomous Regions shall provide for legislative powers over. I'm just curious, Counsel, what your interpretation is of that, the importance of that phrase, subject to the provisions of this Constitution and national laws.
Our interpretation is that the arm operates within the confines of the Constitution. It is not beyond the Constitution. Definitely, and even in fact, Section 17 says that anything which is not granted to the arm under this Constitution or by law is reserved to the national government. So I read this in connection with RA 9054. This section, together with RA 9054, which says at night, under RA 9054, the arm has legislative powers over matters except the following.
I'm sorry, but in the Constitution, the enumeration is positive. Is that not correct?
Yes.
It enumerates the areas where the autonomous region, whatever its name is going to be, is going to have powers over.
Yes, Your Honor.
But the Organic Act has a different kind of enumeration. Is that not correct?
Negative.
It's a negative enumeration. Which shall govern?
I think, Your Honor, both. You have to look at it both. You have to combine. First, of course, the Constitution is there.
If there is a contradiction, which governs?
Of course, the Constitution.
Constitution. As a matter of fact, Section 20 says so. That's subject to the Constitution. Is that not
Yes,
correct?
Your Honor.
But it also says it does not stop there. Subject to the Constitution. It does say subject to the provisions of this Constitution and national laws.
But
What does that mean?
Well, you have to. In other words, when it says it's subject to national laws on areas that are not covered by the devolved powers, because also the Constitution provides that what is devolved to the arm is also those which are enumerated in Section 20, as well as that which may be allowed by law, which is RA 9054.
Is RH law a national law?
Well, it is.
Yes.
It is applied to all.
MMAA 290 and 280, are these national law?
It's an arm law.
It's an arm law. Therefore, is it national law?
292 is a...
Subject to the provisions of this Constitution and national law, the Organic Act of the Autonomous Region shall provide for legislative powers over. So the MMAAs on gender equality, gender and development, as well as reproductive health, produced by the ARM Regional Assembly, are an exercise of the legislative power of the autonomous region. Is that not
Yes, Your
correct?
Honor.
Can that trump national law?
Your Honor, it is our position, presenting from the discussion of this court in Quezada versus Senate as well as in prior decisions, that the Congress is restricted from passing national legislation laws for implementation in the arm
If
on
the
subject
Organic
matter.
Act provides a big power, such as that they can pass matters relating to personal, family, and property relations, that broad,
Yes.
okay, can the Regional Assembly pass a particular law that may be inconsistent with a national law? What is your position on that?
Our position, so long as it doesn't violate the Constitution, yes, it can.
Can you cover in your memoranda, just to abbreviate this interpellation, exactly what is meant by Section 20, the first, the opening paragraph, subject to the provisions of this Constitution and national laws?
Yes, Your Honor.
As you may suspect, this justice is very much interested in the kind of argument that you are going to put up in relation to this particular provision. But let me just complete this interpellation by looking at Section 1 of Article 10. You have that. There is a first sentence to Article 10, Section 1. It says, the territorial and political subdivisions of the Republic of the Philippines, and they enumerate provinces, cities, municipalities, and barangays. So it means only the provinces, cities, municipalities, and barangays are territorial and political subdivisions of the Republic of the Philippines, correct? It goes to a second sentence. It creates a new body, which is, there shall be autonomous regions in Muslim Mindanao and the Cordilleras as herein provided. Is that not correct?
Yes, Your Honor.
Yes. As a matter of fact, Article 10 is divided into 3 parts, right? One, the first is general provisions. Then there are provisions on local governments themselves, and then there is a separate provision on autonomous entities, such as, for instance, Section 15 down to Section 21. Is that not correct?
Yes, Your Honor.
Does this matter in terms of the structure of our Constitution?
We are mindful that the title of the provision talks of local governments. That is the starting point. It considers everything under the title as local governments. But precisely the separate provision for autonomous region provides it in a different standing than other local governments. And precisely in the numerous decisions of the court, it has recognized the different standing of autonomous regions, regions possessing political autonomy, separate from what is granted to local governments, which they define as simply decentralization of power.
Okay. That is all, Chief.
Counsel,
Yes, ma'am.
did you approach the Armed Legislative Assembly about the matter of bringing a petition before this court?
No, we were approached by the petitioner, and on his own, he asked us to file this petition, so we filed it.
Did your petitioner, did your client approach the regional governor
No, he did not.
saying, in other words, you have not approached any of the duly constituted authorities of the arm in the matter of bringing a petition before this court to strike down the RH law?
Yes, Your Honor.
Okay. You are aware of course, of Muslim Mindanao Autonomy Act number 292.
Yes, Your Honor.
You have a copy of that?
Yes, Your Honor.
Okay. Can you read the guiding principles, section 3, paragraph H, in full, please, together with the introductory phrase in section 3.
The following principles constitute the framework upon which this act is anchored on Sharia.
Is anchored on Sharia, and this act is the Reproductive Health Act of the ARMM, right?
Yes, Your Honor.
Okay. Section H, please.
The regional autonomous government shall consider, without bias, all effective natural and modern methods of family planning that are medically safe and legal in accordance with the standards set by the WHO, as well as registered and approved by the FDA, as well as the Assembly of the Rule IFTA of the Philippines.
Okay. Can you go to section 5? Also of the same act.
Your Honor, the provision of midwives for skill attendance.
Okay. Of course, it's quite long, but basically requires the provision of skilled midwives for attendance at birth. What about section 6?
Emergency obstetric care.
Okay. So there is the provision that there should always be emergency obstetric care at every hospital. Section 7, please. And this you read in full, please.
All accredited health facilities in the autonomous region in Muslim Mindanao shall provide family planning services.
Okay. Section 8.
Maternal and newborn health care in crisis situation. The local government units and the Department of Health shall ensure that a minimum initial service package for reproductive health, including maternal and neonatal health care kits and services as defined by the Department of Health, will be given proper attention in crisis situation such as disasters, humanitarian crisis, minimum initial service package.
Okay. Okay. 9, 10, and 11.
All local government units.
You can summarize. We will allow that for now.
Well, 9 talks about LGUs conducting annual maternal death review. Section 10 talks about supplies and essential medicines for reproductive health should be part of all the hospitals and regional government units. 11 talks about integration of responsible parenthood and family planning in the anti-poverty program.
Okay. Section 11, the title is what?
Integration of responsible parenthood and family planning component into an anti-poverty program.
In other words, in the concept of the RH Act of ARMM, the family planning is an integrated anti-poverty program.
Yes, Your Honor.
And the Legislative Assembly sees nothing wrong with the fact that one way of combating poverty is to introduce family planning. That is the concept in the ARM.
But that is
Correct?
that is the concept under 292.
Yes, that's in the
Yes.
concept in the ARM.
Yes, yes.
Right?
Yes, Your Honor.
And you have not brought any action to strike down this law.
None, Your Honor.
Correct. So this law is valid as it stands.
Yes, Your Honor.
Okay. So we have already looked at section 3, paragraph H. It says that acts that there shall be what's the language again? That there shall be consideration without bias of all effective, natural, and modern methods of family planning. Then you have an enumeration of the kinds of infrastructure, budgeting, and even the provision that is required to be put up by the ARM. And it is even said there that family planning is considered as an integrated part of anti-poverty.
Yes, Your Honor.
Correct? Okay. What about the teaching of reproductive health care? Go to section 15, please.
I will read the entire provision.
Section 15, reproductive,
Yes, reproductive
health care
health
education.
care shall be taught by trained teachers or Arabic lecturers in formal and non-formal educational systems starting at the adolescent stage.
Starting when?
Adolescent stage.
Okay, so reproductive health care starting in the adolescent stage. Okay, then what about free instructions on responsible parenthood in section 16? You go to section 16.
Additional duty of the local population officer.
Okay. Okay, go.
Each local population officer of every city, municipality shall furnish free instruction, information on responsible parenthood, family planning, breastfeeding, infant situation, nutrition, and other relevant aspects of this act to all applicants for marriage license and for solemnization of marriage.
Okay. So even a certificate of compliance is required in order that you may get married in the
sure.
arm. Okay. Then let's go to the training of barangay health workers under section 17.
Barangay health workers and other community-based workers shall undergo training on promotion of reproductive health.
Okay. So even barangay health workers are required to be trained to promote reproductive health care. Okay, section 18. What about the approach to persons with disabilities?
Cities and municipalities must ensure that barriers to reproductive health services for persons with disabilities are obliterated in the following manner.
Okay. What about a region-wide information campaign under section 19?
Department of Health, Bureau of Information, as well as religious and indigenous tribal leaders shall initiate and sustain a region-wide multimedia campaign.
Now, this is quite an extensive program of education, financing, and creation of all infrastructure. Don't you agree?
Yes, Your Honor.
Okay. So now, what is the basis? If this is the approach of the Regional Legislative Assembly of ARM, why should we listen to the two petitioners that you are representing and strike down the national RH law simply because they believe that in a general sense, and you have not even formally addressed this in a reply to the comment of the respondents, that it is in fact violative of the Constitution. If this is the state of the law in the ARM, what basis do we have to believe that your clients represent the legal status of reproductive health law in the ARM?
Your Honor, if I may start. As far as petitions are concerned, their standing is that of constituents of the ARM. Their sole purpose in filing this petition is to protect this particular law as compared to RA 10354. Their intent really
But they have never said that there's any problem with them having their ARM Reproductive Health Act together with the national legislation.
Well, precisely.
I have not heard any official statement coming from the ARM.
I will admit that, Your Honor. That
in fact, when I saw this, I was quite surprised that it is quite a radical approach to family planning, where they made a very upfront discussion that in fact it has to be integrated with any anti-poverty program in the ARM.
As we mentioned, Your Honor, the petitioners acted on their own. As far as
so they are really not representing anybody.
They're representing. They're
not even representing the ARM residents. They're just representing themselves.
As residents, feeling that they are doing it for the service of the people in ARM, because they feel that the law itself is all-encompassing. Rather than waiting for the ARM to approach them, they decided to file this petition on their own.
Okay. Do you have a copy of the 2003 fatwa on reproductive health and family planning? Can you read?
Unfortunately, Your Honor.
The second full paragraph of the fatwa.
I will admit, Your Honor, that I do not have the complete text.
You don't have a copy? I will read it to you. It's in one of the annexes in the submissions of the parties. National data indicate that the Philippines, 10 women die every day from causes related to pregnancy and childbirth. Maternal mortality ratio is found highest in the ARM. and northern Mindanao at 200 to 300 maternal deaths per 100,000 live births. Okay, third paragraph. Infant mortality rate in ARM is also very high at 55 deaths per 1,000 live births, compared to the national rate of 35 deaths per 1,000 live births. This is the fatwa that was being, I think, earlier referenced by Justice Leonen. Am I correct? Justice Leonen, this is the fatwa. Okay? In response, meaning to maternal deaths and infant deaths, the government and non-NGOs have been implementing reproductive health and family planning programs in various parts of the country, including Muslim Mindanao. That's the fourth paragraph. The fifth paragraph. Assembly of the Rule Iftar of the Philippines confronted with the issue of whether or not RH and family planning as implemented in the Philippines are in accord with the teachings of Islam. Okay, paragraph 7. Assembly does not find anything objectionable with the above definition of reproductive health, which is the International Conference on Population and Development definition, as well as the following implications of reproductive health that people have the right to understand, including that people have the right to understand and enjoy their own sexuality within the legal framework of marriage and are able to have satisfying and safe sex life with their legitimate spouse, etc. And the right to remain free of disease or death associated with sexuality and reproduction. Okay, several paragraphs down. 2 pages down. Family planning in this sense is not incompatible with its nature and is not disagreeable to national conscience and is not forbidden by Sharia, if not prescribed by it and sought after. The Quran fixed the lactation period at 2 full years, and Prophet warned against feeding a baby from the milk of a pregnant woman. 1 paragraph down from the previous. Sunnah reveals that the principle of preventing pregnancy was evident in the practice which the Prophet allowed his followers. This refers to azil or coitus interruptus and the number of hadith regarding this practice, meaning it's understood to refer to using means of preventing pregnancy. Okay? Several paragraphs down and 1 page later. The preservation of human species is unquestionably the primary objective of marriage, and such preservation requires continued reproduction. However, it allows Muslims to plan their families due to valid reasons and recognized necessities. 1 paragraph down. Grand Imam of Al-Shaqar, Sheikh, etc. stated that a thorough review of the Quran revealed no text prohibiting the prevention of pregnancy or diminution of the number of children. 3 pages later, all methods of contraception are allowed as long as they are safe, legal, in accordance with the Islamic Sharia, and approved by a credible physician, preferably a Muslim, for the benefit of both the mother and the child. And then, its last paragraph, the Assembly therefore finds that reproductive family and health and family planning, as practiced under valid reasons and recognized necessities, are in accordance with the teachings of Islam. So again, I find it difficult to understand what kind of interests your clients represent other than their exclusive position as citizens and taxpayers and residents of ARM. Is that correct? There is no other tangible interest that I can hold on to?
Their interest really is to ensure the autonomy of ARM and making sure that this law, that the current RH law, whether they agree with it or not, will be respected rather than RA 10354.
Okay, thank you. I have no further question. In which case we can now, yes, Justice De Castro.
Just a side issue, you were asked by one of the justices to discuss the nature of the ARMM. Will you take into account that the ARMM is under also Article 10, which is entitled Local Government?
Yes, Your Honor.
And that the ARMM is composed of provinces, cities, and municipalities, which share common and distinctive qualities?
Yes, Your Honor.
And do they lose their character as territorial and political subdivisions of the government, of the national government, just because they are part of the ARMM? And will you also take into consideration that the autonomous region are created within the framework of the Constitution and the national sovereignty, as well as the territorial integrity of the Republic of the Philippines? It's for your memorandum that you're being asked to prepare.
Thank you, Counsel. You're discharged. May we now hear from the Solicitor General.
Madam Chief Justice, Honorable Justices, Your Honors. The Office of the Solicitor General, on behalf of the House of Representatives, the Senate of the Philippines, and the Executive Department of Government. Your Honors, the issue before this Honorable Court is not when life begins. The Constitution, in Article 2, Section 12, textually commands the state to protect the life of the unborn from conception, but it does not define the term conception. While delegates to the 1986 Constitutional Commission disagreed as to its meaning, they agreed that Article 2, Section 12 was intended to constitutionally bar any Congress or any court from ever adopting in this jurisdiction the decision of the United States Supreme Court in the case of Roe versus Wade. Thus, when life begins is not the issue. The constitutional question at hand is whether or not the Congress, in the exercise of its police power, enact the RH law, a social legislation that provides women with universal access to effective, legal, non-abortifacient, contraceptive drugs and devices, and to services and information thereon. In the last 14 years, the Congress debated reproductive health legislation. Last year, 26 years after the advent of Article 2, Section 12, and that is a quarter of a century of advances in science and medicine, Congress passed the RH law. Even then, the Congress, just like the Constitutional Commission, was divided on the question of when life begins. Congress chose not to answer the question. In fact, both houses of Congress rejected proposals to define the term conception. Instead, in common cause with the Constitutional Commission of 1986, the Congress reaffirmed in the strongest, loudest, and clearest terms the anti-abortion and the anti-Roe versus Wade tone and prescription of the Constitution. How did the Congress do this? By inserting two pivotal provisions into the RH law. First, Section 2, Declaration of Policy. Contraceptive drugs and devices should not prevent the implantation of the fertilized ovum as determined by the Food and Drug Administration. Second, in Section 4A, in language which only medical terms can give pinpoint specificity, Congress required that contraceptive drugs or devices must not be abortifacient. That is, they should not induce, and I quote, the prevention of the fertilized ovum to reach and be implanted in the mother's womb upon determination by the Food and Drug Administration. Thus, plainly, whether life begins at the fertilization of the ovum or upon the implantation of the fertilized ovum in the mother's womb, there is no need to judicially resolve this question. Sections 2 and 4A, beyond doubt, guarantee the strict implementation of the compelling state interest to prohibit abortion. Your Honors, Medical experts agree that the fertilized ovum journeys from the fallopian tube to the mother's womb over a period of around 7 days. Thus, sections 2 and 4A could not be any more explicit. During the medical continuum of 7 days that takes place between fertilization up to implantation, anything that prevents the fertilized ovum from reaching and being implanted in the mother's womb is an abortifacient, as determined by the FDA. Your Honors, in adopting sections 2 and 4A, the Congress and the Executive made a contemporaneous construction of the meaning of Article 2, Section 12 of the Constitution. Their understanding is, in layman's terms, the take of the elected and the political branches of government on how to effectuate the state's duty to protect the life of the unborn. This is a view informed by the latest available scientific evidence and decided through that procedure ordained in a representative form of government, a vote of the Congress with the concurrence by the President as head of the executive branch of government. We ask your honors to pay heed to this contemporary interpretation by the people of their Constitution. In the words of this honorable court, the responsibility of upholding the Constitution rests not on the courts alone, but on the legislature and the chief executive as well. All courts cannot but cautiously exercise their power to overturn the solemn declarations of 2 of the 3 grand branches of the government. Does the Constitution prohibit the manufacture or use of contraceptive drugs and devices? No, not by its text, and no, not by the declared intent of the framers. Women have a constitutional right to use non-abortifacient contraceptives and to receive information and services thereon. This right springs from, among others, their due process right to liberty, the right to privacy, including marital privacy, the right to health, the rights flowing from that bundle of layered and nuanced entitlements, duties, and responsibilities under Article 2, Section 12, and Article 15 of the Constitution, and various international conventions which form part of the law of the land, notably the Convention on the Elimination of All Forms of Discrimination against Women. And we hasten to add, central to the exercise of these rights of women, as is central to the exercise of all rights, is that women have the freedom to enjoy or not to enjoy these rights of their own free and informed choice. Women have enjoyed the right to use non-abortifacient contraceptives since under the 1935 Constitution. In 1966, Congress, through Republic Act 4729, allowed the use of contraceptive drugs and devices dispensed by a pharmacist upon a doctor's prescription. Republic Act 4729 defined contraceptive drug as any medicine used exclusively for the purpose of preventing fertilization of the female ovum, while contraceptive device was defined as any instrument introduced into the female reproductive system for the primary purpose of preventing conception. The constitutionality of RA 4729 has never been questioned. No person has been prosecuted for contraception use, and neither has FDA certificate of product registration been questioned. we respectfully emphasize that all that the RH law seeks now is to subsidize for the benefit of the poor, the women, the marginalized, and the vulnerable, contraceptives that have been legally available for the past 50 years to their more affluent counterparts. In 1986, the Constitutional Commission debated the constitutional status of contraceptives. Their conclusion: no constitutional ban on contraceptives. We quote Commissioner Bernardo Villegas, no less the sponsor of Article 2, Section 12. Delegate Commissioner Villegas. As regards the issue of what type of contraceptive devices are abortifacient, I think it is a question of fact, and this can be left to the Congress and to the courts to decide. This is a question best left to the law implementing agencies and the courts actually deciding on the facts presented. So I am not in any way making a categorical statement that all these contraceptives are abortifacient. I think it is a matter of fact that has to be established. End of quote. Your Honors, and this is exactly what the Congress did. It debated the factual question of whether or not abortifacient, whether or not contraceptive drugs and devices are abortifacient, and the Congress received evidence on this question of fact. The proponents of the RH law submitted expert opinion and testimony to persuade Congress that contraceptive drugs and devices as a class are not abortifacient. The most authoritative of this are: number one, the testimony of 22 Filipino experts, and number two, the testimony of the World Health Organization. These fact witnesses submitted testimonials that contraceptives act before fertilization or implantation, and therefore are not abortifacient. The WHO expert opinion especially declared that while all these methods, and I quote, directly or indirectly have effects on the endometrium, which is the mother's womb, that may hypothetically prevent implantation, there is no scientific evidence supporting the possibility that these methods are shown to cause the abortion of an implanted ovum. End of quote. Opponents of the RH law submitted, with all due respect, in our view, meager scientific evidence to the Congress. Our review of the legislative record shows that in the Senate, quotations from a book on the history of contraceptives were cited, and in the House, Representative Rufus Rodriguez of Cagayan de Oro cited 3 medical articles. The literature petitioner Alfie promises only now to make available to this honorable court are completely evidence aliunde to the record upon which the Congress made its findings of fact. This evidentiary gap, with all respect, is fatal. No judicial notice can be taken over such questions of medicine as to what are the mechanisms of action of contraceptives. The conclusions made by Alfie are arguments, not matters of unquestionable demonstration. Our point, Your Honor, is the Congress has made a legislative finding of fact, and it also delegated to the FDA to determine which particular currently available contraceptive meets or do not meet the legislative definition of non-abortifacient as laid down in 4A. In a newspaper column on July 28, 2013, the constitutionalist Father Joaquin Bernas wrote, and I quote, "There are those who argue that contraceptives currently in the market kill life must be able to prove the precise contraceptive devices that are abortive. A sweeping generalization is irresponsible. End of quote. Indeed, the Congress has the reserved power to itself determine which contraceptive drugs and devices currently in the market are abortifacient. But to itself undertake this task would have been ill-advised, given the workload of the Congress and given the many other ills it had to address. Your Honors, as we speak, there are 59 contraceptive drugs and 7 intrauterine devices currently available in the market. Permit us to illustrate. There are 14 compounds used in these 59 drugs, each with its own chemical properties and mechanisms of action vis-a-vis contraception. But each licensed or branded contraceptive may use one or more of these compounds. Of the 59 brands available, we have counted at least 10 combinations in which these 14 basic compounds are used. And there are variations in those for each particular brand. Some brands even vary the dose during the 21-day period when the contraceptives are used. In short, in reviewing each particular brand prior to certification, the FDA must consider a host of variables. Certainly, Congress chose to act sensibly by delegating this fact-finding to the FDA. Certainly, this act of the Congress cannot, by any measure, be in grave abuse of discretion. As a court in another jurisdiction has said, when Congress undertakes to act in terms fraught with medical and scientific uncertainties, legislative options must be especially broad, and courts should be cautious not to rewrite legislation, even assuming arguendo that judges have more exposure to the problem and might make wiser choices. End of quote. One last point, Your Honors. Who authored Section 4A, which petitioners now task the government to defend? Section 4A was crafted and inserted into the RH law primarily by legislators who were opposed to the RH law. In the Senate, Senate President Juan Ponce Enrile and Majority Leader Vicente Soto, by amendments, defined abortifacient to refer to any drug which prevents or destroys a fertilized ovum from being implanted or destroys a fetus inside the mother's womb. These amendments were accepted by Senator Pia Cayetano as main sponsor of the bill. In the House, Representative Rufus Rodriguez, a stalwart opponent to the bill, proposed the insertion of 4A by amendment. This was accepted by main sponsor Edsel Lagman of Albay, who has only to add upon determination of the FDA. Both houses did not need to vote on these amendments. During the BICAM, the Senate yielded to the House version. Your Honors, that is the history of 4A. And so, the government, too, Your Honors, we also ask, at least on the issue of life, why are the petitioners even here? Sections 2 and 4A exemplify the kind of consensus born of political process. They embrace an inclusive definition of what is an abortifacient, agreed upon by lawmakers of differing political and societal views. This consensus enabled the political branches to sidestep the divisive issue of when life begins, even as they agreed to protect the life of the unborn. Your Honors, more important, this consensus allows the people to affirm through their Congress, their chief executive, their universal and unifying commitment against abortion. We respectfully submit that this court respect as well the outcome of this majoritarian process. In fine, Your Honors, we ask you, at this point, stay your hand, lift the status quo ante order, and dismiss the petitions. Deferring to the consensus, at this time, we'll assure the Congress, the Executive, and the Honorable Court the rightful roles in constitutional interpretation. For, and I quote, such dialogue between the branches is the agar of a vibrant constitutional democracy. At all events, Your Honor, after the FDA shall have acted, a direct injury plaintiff can seek redress from the courts all the way to this honorable court. By then, the courts, including this honorable court, will be exercising your rightful case and controversy jurisdiction. Thank you, Your Honors.
Thank you, Solicitor General. Justice Mendoza.
I defer to Justice Abad.
Justice Abad.
In the course of my questioning, I refer to certain provisions of the law and some documents of the respondents. So to minimize time, I have prepared projections so they'll not have to look for it, and I'll find it. So with that permission.
Counsel, you are directed to please refer to the what is going to be projected.
Yes, Your Honors.
Yes. I want to clear up some basic things before going into the issues. The subject matter of the RH law is family planning, correct?
No, Your Honor.
Family planning is
no, Your Honor. It's reproductive law and universal access of reproductive materials to women, the poor, and the disadvantaged.
All right, okay. But one of its components is family planning.
Not family planning, Your Honor. That is not mentioned in the RH law.
Okay, reproductive health.
Reproductive health as one of the many objectives of this law, Your Honor.
All right, so with this in mind, your position is that the legislature is right in enacting the RH law.
Yes, Your Honor.
Is that correct? For the public good.
Yes, Your Honor. As an exercise of police power and as a social legislation.
Concerning your topic, the right to life and implicitly the right to health, correct me if I'm wrong, but I perceive three tests of constitutionality of the RH law here. That's the first one. Does it violate the right to life of the mother and the unborn child? You agree with that?
It does. It does not, Your Honor. It does not, Your Honor.
Does it violate the people's right to health?
It certainly not, Your Honor.
Well,
it does not violate.
And third, does it violate the individual's right to substantive due process? Because you're citing police power, which demands that laws be reasonable, not arbitrary.
There is no violation, Your Honor.
Yes, that's what I'm just saying. These are the issues. Okay. Do you agree that these are some of the tests that you must hurdle, respecting the rights to life and the right to health, that the subject matter of your talk?
Well, it's not an exclusive test, Your Honor.
Now, consequently, if the court finds that the RH law does not violate these constitutional rights, then its validity should be upheld, correct?
Yes, Your Honor.
On the other hand, if the court finds that the RH law violates one of these constitutional rights, then its offending provisions should be stricken down, correct?
That could be a result, Your Honor.
You said in your comment that negative rights, like those in the Bill of Rights, are generally self-executing. You said that, correct?
Yes, Your Honor.
For example, no person shall be deprived of life, liberty, or property without due process of law. That is a negative right.
Yes, Your Honor, as contained in the Bill of Rights.
Self-executing.
As a Bill of Rights right, Your Honor, yes.
in such a case, the power of the court, according to you, is to interpret son's negative right is strongest, correct?
Yes, Your Honor.
That's what you said. You also say that positive norms, on the other hand, are not self-executory.
No, I believe, Your Honor, what we said is many of the provisions in Article 2, as distinguished by the Bill of Rights, the Article 2 enumeration of rights.
So, for example, the Constitution states that it is the duty of the state to equally protect the right to life of the mother and the unborn child from inception. That is a positive norm.
That is an Article 2 right, Your Honor.
But does not such provision also imply that the state cannot deprive the unborn child of the right to life?
It implies more that the
that's
state...
what you were saying a while ago. That,
No, Your Honor. The Article 2 rights say that the state has a duty to protect, and the duty to protect means to act by legislation. That
Yes.
is why we say it is not self-executory.
Yes, but in fact, you yourself said in your comment, page 28, that the Constitution prohibits abortion, which will deprive the unborn child of his right to life. You agree?
That is our conclusion,
Right.
Your
So,
Honor.
this means that in this case, that a positive norm, the right to life of the unborn child, can imply a negative right. Mainly, abortion is prohibited. Correct?
In the sense that it can imply, Your
Okay.
Honor.
The same is true of the constitutional provision that the state shall promote and protect the right of the people to health. It is a positive norm, but it implies a negative right, namely that the state cannot deprive the people of their right to health. Correct?
I would be careful about implying
you
so
don't
many...
dispute that. That's it's
I dispute it as a general proposition, Your Honor, as a stepping stone to some incursions into constitutional right. All it means is that if the people have a right to health under Article 2, then the government has a positive obligation by statute to implement. But considering that there are so many social
Yes,
demands,
yes.
right
Part
to
of
health,
that is,
right to the environment, so I will be very, very careful and hesitant to imply negative rights
No,
to
for example,
such...
can the government perform acts that knowingly will imperil the health of the people?
They cannot, Your Honor, if what they are doing is against a right under the Bill of Rights, right to life, liberty, or property. So if what the government does imperils the liberty or the life of a person, then the government cannot do that. But that's an Article 3 Bill of Rights right.
Yes, I understand that. But I'm referring now to Article 2, no? Where you said there's no provision there that the Constitution prohibits abortion, yet it implies that from the right to life. That's what I mean. No? There's no provision there to... But there's a provision there that right to health. That's a right that is stated there as a right. And that government probably cannot take from the people the right to health. Do you agree with me?
We imply the...
No, do you agree with me that
No,
the
Your
government
Honor, I do not. With all due respect.
Cannot act to impair the right of the people to health? Government can do that?
The government cannot do that because of the Bill of Rights.
Well, that's all the point. Now,
Because of the Bill of Rights, Your Honor, not because of Article 2.
Yeah, well, it's okay. That's good that it gets an assistance from the Bill of Rights.
Not only an assistance, Your Honor. That's the only assistance that you can have.
All right.
Because Article 2 is so many...
But the Bill of Rights does not mention the right to health.
No, precisely, Your Honor, it does not. But then government cannot impair
Only
health.
the right to life.
No, government cannot impair health, not because of Article 2,
Okay, well, I've made
but
my
because
point
of
that
Article
the government... I've made my point anyway. Now, so let me first take up the right to life of the unborn child. My understanding is there are three ways of preventing the birth of a child. One, by preventing the woman's ovary from ovulating or producing ova or eggs. I think you mentioned that. Second, no ovum, no baby. Is that right?
Yes, Your Honor, but this is
Now,
not.
so,
This is
number
not
two-
these are not the only modes, Your Honor.
Yes, number two, by preventing the sperm from fertilizing the ovum.
That's
No.
one. But what we're saying, Your Honor, there are not
No, just
only
answer the
three.
point, whether that's a correct statement or not.
A correct statement, one of many, Your Honor.
All right, now. So, no sperm fertilization of the ovum, no baby. Okay. The third, by abortion after the ovum has been fertilized. Kill the fertilized ovum, you kill the baby. Correct?
I disagree, Your Honor.
Well, that's what it...
Because there is no child yet. And then besides, Your Honor, the enumeration is
No, I'm not. I'm just stating some declassification. I'm not saying that your rule. I'm not going there yet. I'll go to that later. But this merely says that these are the means of for preventing birth. Is that correct?
I disagree with number 3, Your Honor.
Which
because
one?
The number 3.
Well,
Because
that is prohibited by law, but that is a means for preventing birth.
I disagree, Your Honor, because I do not agree with the opening statement. 3 ways of preventing the birth of a child. A child is born, Your Honor. A child is after the delivery there is a child. That's why infanticide is the killing of a child. Now,
We said that the right to life of the unborn child begins at conception.
that is
So
it.
if you say that you call him a child if he's only out of the woman, you're not, what do you call that? You're talking about another thing. That's not what the Constitution checks. The right of the unborn child from conception.
No, Your
if the
Honor.
child is aborted, while he is in the mother's womb, then that is the third part.
With all due respect, Your Honor, the Constitution does not say the right of the unborn child. It says the right of the unborn from conception. That's why we disagree with the premise, preventing the birth of a child.
Well, what is the
Constitution?
unborn? What is the unborn here?
That is
When he is born, what is he called?
A child.
So when you don't call him unborn child?
You are right,
This is
Your
still
Honor.
in the womb?
You are right, Your Honor. There is no such thing as
Well,
an
I'm not
unborn
disputing
child.
that, but
All I'm saying, Your Honor, the Constitution says protect the right of the unborn from conception. It doesn't say child.
No, that is what it says.
No, Your Honor, I disagree.
But,
That's not what the Constitution says.
So what do you call this? The one that is unborn?
It's unborn,
The
Your
right
Honor.
of the unborn what?
The Constitution says the
Unborn.
right of the unborn.
Animal?
I don't know. The Constitution says the right of the unborn.
All right, I'll go to another point. I'll not dispute that because that's not really important. So, abortion is out, correct? Under this law.
Yes, Your Honor. Definitely
but-
out under this law.
Yes, well, but preventing ovulation and avoiding the fertilization of the ovum, they are in under this law. Preventing ovulation and avoiding the fertilization of the ovum, they are legal.
Yes, Your Honor.
And these two permissible modes are made possible through the use of contraceptives, according to you.
Yes, Your Honor.
Now, contraceptives can be in the form, I think there's some that I'll describe, in the form of birth control pills that women take at prescribed time and dosages. All right? These pills are hormonal contraceptives, correct?
Yes, Your Honor.
Their primary function, according to the World Health Organization, or WHO, is twofold. It prevents the ovary from producing ova or eggs, correct? That's the first one.
Yes, yes.
And
Your
the second is that it generates thick mucus that will prevent the sperm from reaching and fertilizing the ovum. If there is one, is that right?
Honor. Yes, Your Honor.
Now, and then the next one are injectables with effects that last for about 3 months, right?
I believe injectables are hormonal contraceptives that instead of being taken orally are injected, Your Honor. But I think they have the
Injectables
same.
are taken through the mouth
No.
or orally?
Hormonal contraceptives or pills are orally ingested. Injectables, I believe, are
Injected.
hormonal contraceptives. They have the same effect in number one, but
Yeah, I'll show that later. But that's one of the things that mentioned is injectables, okay. And then patches that last for 7 days.
I believe again that patches are stick-ons to the skin, but they have the same mechanism of action in your number one, Your Honor.
Yeah, that's good because now, and these injectable, and then you have the implants. The implants on women's upper arms that continuously release drugs from 3 to 5 years. You're aware of that?
I think implants, but I'm not sure if
Now,
they're in upper
this-
arms or 3 to 5
Now,
years.
these injectables, patches and implants, are actually also hormonal contraceptives. Is that correct?
Yes, I agree, Your Honor.
When you say hormonal contraceptive, that means they are synthetic hormones. They are not human hormones.
Yes, Your Honor.
There are also intrauterine devices or IUDs about the size and shape of a small pendant cross. It's very small, about 1 inch in size. Planted in the uterine wall. They prevent conception for 5 to 10 years. Is that correct?
Well, the concept of the IUD,
Now,
Your
it
Honor.
depends. Now, one kind is made of copper, tanso, that releases toxic particles into the womb and kills sperm cells, right?
Well, I believe
Well, I got that from WHO report.
I believe it's copper, but I don't know, Your Honor, whether toxic is.
Well, there's
but
well,
it
it's-
kills sperms. The effect, I think, is to kill the sperm. Yes.
Well, it kills the sperm cells.
Yes,
You don't
yes, Your
call that
Honor.
toxic?
I do not know whether the proper term is toxic, Your Honor, but it kills.
From my point of view, a chemical that kills cells will be toxic. Now, one kind is made of, another kind is of IUD, releases synthetic hormones into the womb, inducing thick mucus that makes it difficult for the sperm to reach the ovum. Is that right? You also heard of that?
I'm not sure about what another kind means, Your Honor.
This is hormone-based also.
Well, I believe all they call COCs, combined oral contraceptives. The hormonal contraceptives have
Okay.
as a mechanism the thickening of the cervical mucus to prevent the sperm from reaching the egg.
Yeah, well, actually, the whole problem here, as far as I can see, is that the law says that abortee patients, which cause abortion, is prohibited. Huh? It's out. You cannot, the law does not authorize abortee patients, correct?
There is no problem, Your Honor.
Yes. But the problem is that, no, there's a problem because
There is
the,
no
the
problem,
law,
Your Honor.
No, I'll show you the problem. But the law declares in Section 9 there that hormonal contraceptives and IUDs are safe, legal, non-abortifacient, and effective. That's what the law says, correct?
There is no problem, Your Honor, because
No, I'm asking you if that is what the law says.
I disagree with the conclusion, Your Honor. That is
No,
what
no, not the
that is
conclusion.
what Section 9 says. But there is no
Let's
there is
go
no.
one by one. No, I'm sorry.
Can
I'm
I
only
speak,
asking
Your
you if-
Honor?
I'm only asking you if that is what the law says.
Yes, but you had the previous question where
No, I'll go to that later. I'll not surprise you.
can I be allowed to go to it now, Your Honor?
Not
I would-
yet, not yet, because I'm just asking you whether that is what the law says.
But Your
I'll
Honor,
go into the issues. Don't worry, I'll go into the issues.
Your Honor, I am not conceding that there is a problem because 4E defines what an abortive patient is.
No,
There
the
is
problem
no
is not-
problem.
the problem is not with you. The problem is that the petitioners challenge this. That's the problem.
I do not know why they are challenging
No,
it
that's
because
what-
4A
No, that's
protects
what,
everybody, Your Honor.
Well, that's not-
Section 9 says you can only buy contraceptives that meet the 4A criterion. And so it is safe, Your Honor. There is no problem. That's why we also ask, why are the petitioners even here?
And also, the law says, Section 9, that these contraceptives should be included in the National Drug formulary, also known as the essential drugs list, correct?
Only and only if they meet the definition of 4E.
Yes, we
That
did.
they don't have the so-called third mechanism of action, Your Honor. So it's very clear there is no problem, and that has to be taken up yet by the FDA. So you cannot have the Department of Health putting it into the formulary or the essential drugs list unless and until and after the FDA says that particular contraceptive meets the requirements of 4A. So there is, with all respect, Your Honor, there is no problem.
Well, that's not what the law says. And the law mandates the National Drug Formulary to include this class of contraceptives. It says not to include hormonal contraceptives, intrauterine devices, injectables, a safe, legal, non-abortive patient, and effective supplies.
Yes, Your Honor, but please don't forget, this is already Section 9. 4A, which is, number 4 is definitions. The definitions in 4A already says what is the meaning of non-abortive patient. 4A says, provided it is not like this, like that. So by the time you go to Section 9, it means non-abortive patient meets the definition of the Congress in 4A. So again, with all due respect, there is no problem, Your Honor.
Okay.
The problem is the FDA is not being given the chance to make its tests as to whether or not a particular brand, a particular contraceptive, as we say, there are 59, Your Honor. It is, as Father Berna says, quite irresponsible to say all 59 are valid. For that matter, whether or not all 59 meet the 4A test is still for the FDA to determine. So that there is no problem, Your Honor. That's what we're trying to say. There cannot be a 9 unless the FDA first applies 4A. The government concedes that you cannot put anything into the National Drug Formulary. You cannot put anything into
4A is definition of terms.
Yes, Your Honor.
So it merely defines terms. It's not really...
I beg to disagree. It is not merely it defines. That is the crux of the law, Your Honor. It defines. And as I keep saying,
yes,
that came from the opponents of the RH law, not from the sponsors. Not from the sponsors.
Well, I'll go into that, but actually, so, now, if we uphold this law, the government will be free to promote all these contraceptives that it declares to be safe and non-abortive patient, correct?
No, Your Honor.
No.
The Section 9 says that not assuming all 59 meet the 4A test, you have to go to the National Formulary System, which is the most efficacious in terms of cost, and they will come up with the list so that the poor and the privileged and the disadvantaged will only get the best available.
But the law as written, it already says that. Section 9. The National Drug Formulary shall include. So, shall is a command, is it not?
Yes, Your Honor. But then
shall, you have... Well, all right. Shall is a command. Shall include hormonal contraceptives. This is a class of drugs,
But you have...
Intrauterine devices, injectables, and other safe, legal, non-abortive patient and effective family planning products and supplies. Actually, I read your comment, and your comment said that this is a finding of fact of the legislature, that these are safe, and that it is binding upon Supreme Court. This statement, this finding, that this class of drugs are safe and an abortive patient is binding upon this court. You said that, did you not?
No, Your Honor. With all due respect, we're saying we beseech this honorable court to consider that finding of a co-equal branch of government as being worthy of some respect. Of course, it is for this honorable court at the end of the day
I don't
to
know.
pass
but,
judgment on whether the Congress acted in grave abuse of discretion. And all we're saying is the Congress is not necessary. The test is not whether the Congress is correct. The test is, did the Congress make this judgment in good faith based on some evidence as to be not in abuse of discretion? We're not saying the Congress or the executive is perfect, Your Honor. All we're saying is, and the WHO has been quoted, 24 Filipino experts, that is their considered view. The Congress heard this in testimony. 14 years, they arrive at a decision. They are a co-equal branch
Let
of
me
government.
read from your own pleading. The RH law promotes access to contraceptives and not abortive patients. That a contraceptive is not an abortive patient is a legislative determination that is entitled to judicial deference. That's what you said.
Deference, Your Honor. I never said it's binding.
That's what it is. We must defer to it. So,
Deference, Your
therefore,
Honor, with all due respect. We're not imposing on this court.
you said, no, that contraceptive is not an abortive patient, is a legislative determination.
Yes, Your Honor.
So, how can you say that this law as written, that you have to depend upon the FDA when the law itself says that, as you self acknowledges, says that a contraceptive is not a contraceptive. That's a class of medicine, not Daphne or Traspil, which you get to the drugstore, but contraceptive in general as a class is not an abortive patient. It's a legislative determination that the court should respect. So what are you saying? That this is not what you mean? That's what you said in your comment, and that's what the language of the law says.
That is what we said, Your Honor, and our answer would be this is classical administrative law. The Congress makes a policy determination, finding of fact, that contraceptives as of 2012 as a class are not abortifacient. They now delegate to the Food and Drug Administration,
Anyway, so this law,
as an expert, Your Honor, to go down to the level of particular brands and make a finding of fact. Again, we said, can the Congress reserve to itself?
well, I have a problem if your own interpretation conflicts with the language of the law, because we are bound by the language of the law, not by your interpretation of it. That's what you say.
It's not our interpretation. It is an interpretation based on the received teachings of this honorable court in administrative law. The Congress can pass, as a matter of policy, general policy statements. That is why we have administrative law. You give to the experts. You give to the experts in the
I got to another
FDA.
point. You said in your comment that the legislative determination, the legislature conducted hearing, you said received evidence, and after a while it made a finding, determination, that those contraceptives are not abortive patients. And you say in your comment that this finding is supported by scientific evidence of the highest standards, correct?
Yes, Your Honor.
Now, you base this claim on the fact that such determination was based on the opinion of the World Health Organization, or WHO. It is all over your comment, correct?
Among others, Your Honor. There are also 24.
Yeah, but mainly you were citing the WHO. And a group, the other thing that you said, and a group of Philippine medical experts called the Universal Healthcare Study Group, or UHC, right?
Yes, Your Honor.
Now, in fact, you attached the papers that the medical experts in these two organizations gave to Congress. You attached them to your comment.
Yes, Your Honor.
And it was largely based on this evidence, according to you, that Congress made that declaration in the law that these contraceptives are non-abortive patients, correct?
We are saying, Your Honor, that the Congress, this evidence was before the Congress. Now, the Congress, the legislators, the senators may have their own readings, they have their own stuff. What we're trying to emphasize is...
I'm just reading what you said.
This is evidence of record, Your Honor.
Okay.
Evidence of the legislative record.
Now, you cited in your comment the WHO finding that hormonal oral contraceptives like the pill prevent ovulation, right?
Yes, Your Honor.
And that IUDs prevent fertilization, correct?
Yes, Your Honor.
But both methods cannot be labeled as abortifacients, right?
Yes, Your Honor.
That is the conclusion made by the reproductive health experts of the WHO, correct?
And 24 Filipino
and the
scientists.
other one, UHC.
Yes, the 24 Filipino scientists.
Did you bother to find out if WHO, from whom Congress solicited this medical opinion, is impartial on the issue of contraceptives?
That is a question that was automatically
I asked
addressed.
if you bothered to, you're not answering the question. Did you bother to find out if WHO, from whom Congress solicited this medical opinion, is impartial on the issue of contraceptives?
I cannot find out, Your Honor. I would assume that the Congress, the House of Representatives, and the Senate, being elected by the people, have the good sense and the responsibility to make sure that they make good faith judgments on the evidence presented before them.
We should rely always on WHO. The fact is that the WHO advocates the use of contraceptives to control birth, correct?
I do not agree, Your Honor. And again...
No, so let me read. If you don't agree, I'm going to read to you. From the WHO Medical Media Center on Family Planning fact sheet there, dated May 2013. WHO is working to promote planning by producing evidence-based guidelines on safety and service delivery of contraceptive methods, okay? Developing quality standards and providing pre-qualification of contraceptive commodities and helping countries introduce, adopt, and implement these tools, contraceptives, to meet their needs. Now, that's an official statement of WHO. Does that not show to you that the WHO, a UN organization heavily funded by the US aid, wants to export to us their contraception culture?
First, Your Honor, with all due respect, I do not know the source. And number two, Your Honor, with all due respect, I do not believe the World Health Organization is supported by the
I got this from
US aid.
I
Now,
have the documents. I'll show you the documents.
and I would be willing to look at the documents, Your Honor. What the government's understanding is, if a country embarks on reproductive health, the WHO is ready to assist. If they do not want reproductive health, the WHO does not assist.
Counsel, that's not my point. My point is impartiality. You ask for an opinion of an expert, you must be sure that the expert is impartial on that issue. No, that's another point. I'm going to...
That, Your Honor, is addressed to the 24 senators and the more than 200 congressmen. Did they want to believe or not? All we're saying is this court cannot supplant the judgment of 24 senators and the congressmen. Whether they believe it or not, is best left to the judgment. At the end of the day, they passed the law, Your Honor. And that is the only scientific evidence of record. We challenge the petitioners to submit their scientific evidence of record presented to the Congress.
Only WHO is the scientific evidence?
I am not saying that, Your Honor. I am saying the petitioners did not submit into the legislative record scientific evidence, not from our reading of the legislative record. This is all about grave abuse of discretion. We got this in the
website of the WHO. It's accessible by everybody, the legislature. There's another point. It reads also, no? From the same WHO paper. WHO is also developing new contraceptive methods, including male methods, to reduce the unmet need for contraception. So actually, this WHO is in the production of contraceptives. The one you ask, whether this contraceptives acts as abortifacient, is one that promotes its use. So, and it knows that if we say it's an abortifacient, then its product will not be able to enter our country.
I vehemently disagree, Your Honor. And this is the same WHO that only weeks ago the petitioners were quoting on cancer research. We're quoting that contraceptives are supposed to be cancer-producing. So we have to make up our minds. And
Well,
I think the point, Your Honor,
so-
is in the face of conflicting evidence, the Congress acted. And they acted, you have to grant them in good faith. And one could disagree. That's why we are saying
They're looking for
the
evidence.
judgment is not whether they are correct or not whether they believe it or not.
Well, according
The
to you, Congress
majority-
believed that. Also, according to you, Congress believed the WHO.
Because of our conclusion, Your Honor, that they passed the law. And, again, I
Well,
go back, because that's the only
So,
scientific evidence
the
of
medical
record.
experts who prepared these opinions that you attached to your comment, which was relied on by Congress, work for World Health Organization. No? It says there, they're officials of the World Health Organization. Now,
No, Your Honor, I respectfully and
you did not
vehemently
read your,
disagree.
your annexes to find out who prepared this?
No, I also would like to read my annexes, Your Honor.
No, they are prepared by
Let's
WHO.
look at the annexes now, Your
Okay.
Honor.
By employees or
No, I vehemently
experts of
object, Your Honor. It is not
WHO.
true.
No, it tries under the letterhead of WHO.
No, Your Honor, not the...
Well, anyway,
I can look at the comment now, Your Honor.
if you want
Can
to
we
get...
look at the comment now, Your Honor?
No, I'm going to ask you a question. If you want to get an impartial opinion on which television station in the Philippines is the best, would you ask Chris Aquino, who works for ABS-CBN?
I'm sorry, Your Honor.
If you want to get an impartial opinion on which television station in the Philippines is the best, would you go to Chris Aquino and ask her?
I would
But
go.
we-
I would.
You
I
will.
would go to the professionals, Your Honor. Nielsen. There are professional groups that measure.
Yes, that's the proper thing to do.
Of course,
Not
Your
the-
Honor, it's
not
the proper.
those who work for those, you don't consult the experts who work for those whose advocacy is birth control.
That is why, Your Honor, with all due respect, and we
I'm
look
glad-
at now
I'm glad
the
you-
testimony.
I'm glad
of
you
the-
appreciate that point now. There are many outstanding international research groups in the world that do not get funding from pro-abortion world powers. Don't you think that it would have been more prudent for the legislature to ask them their opinions?
The legislator gave their opinions when they voted, Your Honor. But again, just on the 24 Filipino scientists, Your Honor, their letterhead says Universal Healthcare, UHC, Study Group, Room 125, National Institute of Health, University of the Philippines, Manila, 623 Pedro Hill Street, Ermita, 1000, Manila, Philippines. There is not a WHO affiliate, unit, or employer, Your Honor.
You're referring now to the UHC study group, correct?
Yes, Your Honor, because
Now,
these
but
Filipinos,
they gave this
424,
opinion-
are not employees
No,
of the
did you read that opinion?
Yes, Your Honor.
That opinion was based on their belief. You read that you can consider abortion only with respect to viable fetus.
I'm
Not a
dis-
mere fertilized ovum. That's what they say. I want
I
you
am
to
not
read.
disputing that, I am disputing your statement that they are WHO funded employees. They are
No,
not,
okay.
Your Honor.
I'm just telling you that-
It is a dishonor. One of them, in fact, is here.
Those to whom you are referring to now, the Filipino experts, are in another planet because they consider abortion when the fetus is already viable.
No, Your
No.
Honor. We are proud that there are 24 Filipinos.
No, I'm proud of them. No, I'm not saying I'm not proud of them, but they are addressing the wrong problem.
No, Your Honor, they are patriots who gave an opinion to the Congress, and the Congress believed them. We should be proud of these 24
So you
Filipinos.
accept- so
That's
you
why
accept-
it's not only the WHO that the Congress believed. The Congress believed 24 Filipinos. Now the question to us is, on the other side, how many experts were produced? We're saying none.
So you accept their proposition that consider abortion only with respect to viable fetus.
No, Your Honor, the government's position is very clear.
That's what they said. No?
That is what they said.
That's what this expert you said we should believe.
Not on
Project.
that position, Your Honor. The position of the government is very clear. 4A, whether it is fertilization of the ovum or implantation, you cannot prevent the fertilized ovum from reaching or being implanted in the mother's womb.
All right.
That is the government's position.
Well,
Your Honor.
relying on the WHO. So let's now look at some of these WHO statements. WHO said in its expert opinion, November 7, 2006, page 4, Annex 1, that when used appropriately and in doses/ways recommended, none of these methods have been shown to cause abortion of an implanted fetus. In effect, WHO says that take this pill every day on the same hour. If you don't, there is fertilization, and there is fertilization of the ovum. Nonetheless, we don't know if the contraceptives you take will cause abortion. In fact, that's what they're saying.
No, Your Honor, that is not what it says.
Well, in effect, let's say that what it said is the one there on the top.
No, it does not say it textually. It does not say it in effect. With all due respect, Your Honor.
Well, it says there, no? When you use you were given 28 pills. Okay, you use it one each day, okay? And now, if you fail, if you fail one day, for example, no? And there's fertilization of the ovum, that can happen. You failed one day, you drop one pill one day or two pills one day, there is fertilization of the ovum. It says that none of these methods, these pills, have been shown to cause abortization of an implanted fetus. So it says to say that we don't know, it says, if the contraceptives you take will cause abortion.
I respectfully disagree, Your Honor. That is your conclusion.
Well, anyway.
My own plain reading, all it says is, take this dutifully in recommended doses. This is not shown to cause abortion. I, with all due respect, Your Honor, the text and the implication, I completely, with all respect, disagree
When
with you,
you say
Your Honor.
not have been shown, means say there's no evidence, no? None of these methods have been shown
Yes, Your Honor.
to cause abortion on an implanted fetus.
And that's
if
correct.
you fail, no?
And that's correct, Your Honor.
Okay, so anyway, next, further, WHO said that when used appropriately, none of these methods have been shown to cause abortion. Well, no, the other one, let's see. The WHO said in its October 27, 2010 position paper that all the contraceptives it described, including IUDs, directly or indirectly have effect on the endometrium. Do you know what the endometrium is? It is the lining of the, what do you call that?
The mother's womb.
Uterus, no?
Yes, sir.
Where the fertilized ovum are implanted, correct?
Yes, Your Honor.
Okay. So, the IUDs have effect on the endometrium that may hypothetically prevent implantation. However, said the WHO, there's no scientific evidence supporting this possibility. Correct? That's what it says.
Yes,
Now,
Your Honor.
a hypothesis, according to Webster, is a proposition tentatively assumed in order to draw out its logical or empirical consequences, and so test its accord with the fact that are known or may be determined. Okay? Now, this means that given what the science knows, contraceptives would logically or empirically damage the endometrium and prevent implantation. But WHO would make no commitment either way, since science, according to it, could not yet produce evidence that this is the case, that the hypothesis is correct. You get it?
I disagree, Your Honor, with your proposition.
What is your disagreement with this?
Precisely, the plain reading of what the WHO said is the so-called third effect, the
hypothesis. We're dealing with hypothesis here.
No, the WHO did not hypothesize. It is the WHO said that this so-called effect is a hypothesis. The WHO made a flat-out statement. There is no scientific evidence that it causes abortion. All that the WHO said is, well, yes, there is this hypothesis, and maybe it will cause like this, but there is no scientific evidence to prove that hypothesis. That is the reading, Your Honor. The plain reading.
Hypothesis, but it admits that there is a hypothesis. Because, for example, you say if you drink this 1 cup of poison, you're going to die. But we will never know until you drink this cup of poison. That's hypothesis. This is the one also, no?
No, Your Honor, they're different.
Given science, if you use this IUD, then the lining of the womb will be affected. Hypothetically, no, it will prevent implantation. It means it will become an abortive patient. It prevents implantation.
That is why that is
hypothetically. You only say that there's no evidence. So, in our opinion, there is no danger. It is not abortive patient because we have no evidence.
That is precisely, Your Honor. All the WHO was saying is this is a plain hypothesis. At the end of the day, whether your version is right or whether my version is right, what made the big difference was the Congress, the House, and the Senate. These are right-minded patriots. They read the evidence. They believe that they are not
You
about
think the other side have no patriots? I don't think we should refer to either side.
I never said that, Your Honor.
Patriots.
That's why
we can differ and not be not unpatriotic.
No, Your Honor, I never
because
said
you're
that.
Referring to.
I'm referring in the sense of this interpretation, Your Honor. Because again, we're not talking about whether your reading is correct or my reading is correct. It is whether the Congress, in making their reading, acted in grave abuse of discretion.
I think I've made my point. So I'll go to another point. The WHO said in its November 7, 2006 expert opinion, page 3 of Annex 1, that given the use, that during, November 7, given the high efficacy of combined oral contraceptives in preventing ovulation, it is very unlikely that interference with implantation is a primary mechanism of contraceptive action. Well, primary means first, isn't it?
Yes, sir.
There's secondary when you say primary.
Yes,
well, for example, my primary interest is books. My secondary interest is movie. All right? So it says that it is very unlikely that interference with implantation is a primary mechanism of contraceptive action. Now, WHO repeats this point in another paper. Both statements imply that interference with implantation if not a primary mechanism of contraceptives, is its secondary mechanism. That's why I said, oh, my primary interest is, when I say a primary interest, you imply that there is a secondary interest. Because you'll just say, my interest is books. Why do I have to say my first interest is books? If my only interest is books. So that it implies that there is a second function. Correct?
Yes, Your Honor, and that is why the Congress came up with 4A.
Okay.
4A is on the third, the so-called third mechanism of action. The Congress already says, if a particular brand of contraceptive prevents a fertilized ovum from reaching or being implanted, then it is abortifacient. That is what the debate is about. The Congress read it correctly.
But it is referring to interference with implantation.
Precisely, Your Honor. 4A is all about interference with
implantation.
the fertilized ovum reaching
Okay. So,
and being implanted. And that exactly is the remedy of 4A. Why we keep repeating there is no issue, Your Honor. The Congress recognizes that there may be a third. That is why they're saying, FDA, you are the expert. Find out. Not 59, because the 59 are different brands. Go per brand. Does the particular, does trust, for example, as was exhibited the other two sessions, does it prevent, again, the fertilized ovum from reaching or from being implanted into the mother's womb? That is a triable question for the FDA, Your Honor. The Congress knew that and they put that into 4A.
Okay, another point. WHO said also in its November 7, 2006 expert opinion that, and I quote, during the use of copper-releasing IUDs, this is the one that I said in the shape of a cross, more or less, about 1 inch. Copper-releasing IUDs, according to WHO, the reaction is enhanced by the release of copper ions into the luminal fluids of the general tract, which is toxic. This is what I told you, that WHO itself says toxic, which is toxic to sperm. All right. And how does this affect the uterus, where the fertilized ovum is supposed to implant itself? Do you know?
Our answer again, Your Honor, is 4A. There are 7 IUDs presently licensed by the FDA. So again, the triable question of fact, IUD, particular brand, 1 out of the 7, 7 of the 7, do they, because of the release of copper ions, do the release of the copper ions, do they prevent a fertilized ovum from reaching or being implanted? Again, we can just go back. This is a circuitous
I think you are over-relying on the FDA because...
No, I am not relying on... I am relying on 4A, Your Honor. That's the law.
These IUDs and these hormonal contraceptives you're talking about, as you said yourself, are already in the market.
Yes, Your Honor.
Okay. So if you say that the FDA is looking at it really seriously, you see, why is it that the WHO itself says that it releases toxic substance that kills the sperm, and the FDA has nothing to say about it?
The FDA,
are we going to rely on this agency?
The FDA, with all due respect, Your Honor, cannot say anything yet because the implementation of the law has been enjoined. And this requirement, the FDA, as a matter of general statute, passes upon all the drugs that we take efficacy, purity, and safety. 4A, in effect, in respect of contraceptive drugs and devices, adds a 4th category. Not only must the FDA say this drug is safe, pure, and effective, they must, if it is a contraceptive drug or device, they must now say it does not prevent the fertilized ovum, and the mantra is the same, from reaching or being implanted in the mother's womb. That is a new requirement, Your Honor. That is why they are geared to look into that. But how can they look into that when there is
FDA can do
order?
that. Are you aware that all these contraceptives that we're mentioning are imported from Thailand, Pakistan, India? You mean to say that the FDA has laboratories in these places that is screened? They are imported by these organizations, almost all of them. So this must be, what are you talking about? That the FDA is able to really monitor these drugs that come from Pakistan, Karachi.
They do, Your Honor. The imported drugs are tested for safety, purity, and safety. How do they do it? Before they issue a certificate of product registration, for example, if it comes from the United States, they will look at a certification from the US FDA. If it comes from the EU, they will look at the certification from the EU. They, on their own, may call for field testings. That is what the FDA
They
does.
can do that, but as a rule, even in the FDA in the United States, from what I know, it's the burden of the manufacturers to produce what they did. It's not really as if
Certainly, Your Honor.
the FDA has a means to really conduct its own experimentation.
You are right, Your Honor. It is the proponent, it is the manufacturer, of course, of the product that goes to the FDA and says, I would like to be licensed. Now, the FDA has a list of requirements. Among them, the certificate from, for example, if it comes from the US, from the US FDA. So they're doing their duty, Your Honor. But as I'm saying, RH law now gives, in respect of contraceptives, and a fourth requirement that before they can be eligible to be put into the EDL or the National Drug Formulary, the FDA must certify. And the mantra is the same. Do not prevent the
I was
fertilized
asking
ovum.
you earlier what the effect of what does the IUD, what is its effect on the uterus where the fertilized ovum is supposed to implant itself? Actually, WHO answers that, no? In the same paper. The major effect, it says there, of all IUDs is to induce a local inflammatory reaction in the uterine cavity. According to Webster, an inflammation is a local response to cellular injury. There's inflammation when there is cellular injury. We all understand that. Pag nabukol ka, or you cut your, there is damage to our cells. In other words, IUDs, by HEO's definition, harm the uterine cavity where fertilized eggs are implanted.
We respectfully disagree, Your Honor.
You disagree with WHO?
We respectfully disagree because indeed the mechanism of action of an IUD is to cause an inflammation where there are compounds that kill the sperm. Now, but insofar as the FDA is concerned, they have passed upon that the 7 IUDs are safe. Meaning, yes, there is an inflammation. Yes, they act as spermicidals, but they are safe, Your Honor. The FDA will not pass upon it if they are not safe. All you're saying is the mechanism of action is copper causes some inflammation. There are compounds which kill sperm. Yes, there is an inflammation. I'm not a doctor, but the FDA, as an expert, are saying that kind of inflammation is seemingly acceptable. Otherwise,
this is
they will
the
not
WHO talking, huh?
Yes, Your Honor.
According to you, your experts at the WHS.
And I have no problem with that, Your Honor.
Now,
what I'm saying is it is still safe.
Do you know what these poisonous elements would do to the cell that make up the endometrium or outer lining of the womb?
I do not know, Your Honor, but that is addressed as a matter of safety.
They are also made up of
FDA.
cells. Do you realize that?
I am not a doctor, Your Honor, but again, that is a matter to be addressed by the FDA.
Now, okay, let's go to another point. Is it possible to have fertilization even with IUD?
I believe so, Your Honor. There are failure rates.
So the IUD is a foreign object, like a cross, implanted, and the uterus where the baby is also implanted. So if there's fertility, according to WHO, okay, here, studies on recovery of eggs from women using copper-bearing IUDs and from women not using any method of contraception show that rates of embryos, which are fertilized eggs in advanced stage, formed in the tubes, that's the fallopian tubes, are much lower in copper-bearing IUD users than those not using contraception. In other words, sperm can survive even in IUD situation, according to WHO.
I believe that's theoretically correct, Your Honor.
So
Because no
fertilization,
contraceptive is 100% effective. That's my understanding. There is a so-called failure rate.
okay, so that's fine, because that's the only point I want to make. Now, another one, WHO admits in its November 7, 2006 expert opinion that progestin-only hormonal contraceptive can cause the endometrium. Ito yung where the implantation takes place. Where fertilized eggs are implanted to suffer injury. WHO said, progestin-only methods also cause changes in the endometrium. Yan sinasabi ko. No? That poison will not kill only the sperm. It will kill also the cells of the endometrium. Okay. Let me see. However, these changes show great variability among patients. From atrophy. Atrophy, nag-atrophize yung endometrium where the sperm or the fertilized ovum is placed. Nangayayat or wasting away to normal secretory structures. Now, my question is, if the endometrium has atrophied, what will happen to the fertilized ovum that failed to implant?
The studies would show, Your Honor, that there is no correlation because the findings are that there can even be implantation in the fallopian tube where it's not supposed to be. So, Your Honor, these are all hypotheticals.
The WHO itself says that there can be surviving fertilized egg that can... But if it goes there and it's atrophied, it will die. Don't you agree it will die?
No, Your
There is
Honor.
abortion, in fact,
No, Your Honor.
of the fertilized egg.
No, Your
because
Honor.
of the use of the... What do you call that? Of this intrauterine device.
No, Your Honor. Progestin-only methods are only one of the methods. The other methods are the ones that the hormone-based progesterone, Your Honor. Progestin, I believe, is among others those for lactating mothers who already have to take it. So the women have a menu of contraceptives to rely upon. All they're saying is progestin-only methods may have these effects.
Okay.
But they do not say that the effect is an abortion, Your Honor.
Okay, that's your answer.
That's the answer,
Okay,
Your
now,
Honor.
the UHC study group that you are mentioning, the Patriots, submitted their view that contraceptives do not cause abortion, right?
Yes, Your Honor.
But they gave this opinion based on their belief that you can consider abortion only with respect to viable fetus, not a mere fertilized ovum. That's what they say here, no?
No, Your Honor.
No, I'll read first. Abortion, according to them, is the termination of an established pregnancy before fetal viability. Parenthesis, the fetus' ability to exist independently of the mother, close parenthesis. Aside from the 50% of zygotes, these are fertilized eggs, that are naturally unable to implant, an additional wastage of about 20% of all fertilized eggs occur due to spontaneous abortions. So this study group speaks in a different language than the language of the law, because the language of the law is conception or begins at fertilization, but theirs is with there's only what they call there's only violation of the life of the unborn from the time of viable fetal viability. Okay. So
No, Your
consequently,
Honor, that is only correct insofar as the first sentence
Well, anyway,
is
this is
concerned,
the-
on which I have agreed the government has a different position on the first sentence.
No,
The
I'm only
position
saying
of the
this because-
government
yeah.
is 4A.
I'm only saying this because
Because, Your Honor,
this is
your
the level
question...
of their this is the level of their opinion. No,
No, Your Honor. They have an opinion on what constitutes an abortion. They have a different opinion on contraceptive effects. The two are different, Your Honor.
I'll go to that. Actually, I'm going to that. Would you know what the best evidence would be that drug manufacturers produce hormonal contraceptives that in fact function as abortion drugs or abortifacients? Would you know?
I'm sorry,
Would you
Your
know what is the best evidence that manufacturers produce hormonal contraceptives that in fact function as abortifacients?
I do not believe there is one
You
single...
don't believe them? I'm asking you, do you know what is the best evidence of that?
For that matter, Your Honor, the government will challenge. Nobody knows, because that's why in the proposed IRR, permit me, this is what the FDA is supposed to do. Check the compounds.
You are saying that actually the FDA relies on the manufacturer's research. Yes, actually, you say that. You
Not only
consider
that, Your Honor, not only that, if
No,
you will
not
allow
only
me.
that, but among the other things, they rely on the manufacturer's presentation, evidence, etc.
As a starting
Okay.
point, because
So-
certainly it is the manufacturer who brings the product
All right, yeah,
to
now.
the FDA.
Section 2 of Rule 129 of the Rules of Evidence provides that a court may take judicial notice of matters which are capable of unquestionable demonstration. You have heard of this rule?
Yes, Your Honor.
Now, all one need is buy this contraceptives pack. I left it in my office because but I have the inserts. You read the inserts. All right, now. And it says, I'm going to read from one of them. No? The brand name is, I don't know the correct pronunciation, Daphne. Or Dapan, I don't know the correct pronunciation in France. No? Brand of Linstrenol. It says, and I quote, pharmacology. This is a description of the manufacturer of its product. Pharmacology, mechanics of action, effects on endometrium. Linestrenol Daphne impairs implantation. You see, impairs implantation. Perhaps, that's an abortifacient. Perhaps by altering its special receptors for hormones. It may also be indirectly impaired. Implantation is indirectly impaired by interfering with the corpus lutein. All right, another one. Effects on tubal action. Linestrenol Daphne affects tubal secretions and microvilli. Hence, blastocyst and ovum, these are fertilized eggs, transport are delayed. Now, that delay can kill the fertilized ovum. You understand?
That will be taken as part of the evidence, Your Honor. The FDA will have to make a judgment. If somebody contests it, it will be brought perhaps to the Court of Appeals and ultimately to this honorable court.
But it's been a long time that the Constitution was in 1987, and the rules of the FDA prohibit the approval of abortifacients. I don't think that is approved by the FDA.
No, this is approved, Your
But
Honor.
the problem is this one also acts as contraceptive. That's the whole problem about this case, you know? This
Assuming,
medicine is valid in the sense that it is a contraceptive, but it is a double-barreled gun, ano? You fire one shot, contraceptive. You fire the second shot, abortifacient.
that is why, Your Honor, there is, again, 4A. Because, as Father Berna says,
For
do
A is
not
definition of
generalize.
terms. It does not mandate anything. It's a definition of terms. I don't know how you can
With all
find a rule
due
of law in the definition of terms.
With all due respect, Your Honor, rule of law is precisely 4A. Because without 4A, then anybody can say, this is my view and that is my view. This is my religious view.
No, by
this
the way,
is my
I'm
political
going
view.
also into that. No,
Under
later on.
4A, then, if this particular brand does not pass, then it does not pass, Your Honor. That
So
will
let
go
me
up
read,
to this
no?
honorable court. But that is what Father Bernas is saying. Do not generalize. It is not responsible to generalize. If this is what one branch says, they have to account for it in the FDA.
So let me read from this inset of trust pill that you have to trust. Trust pill. If you brand of ethinyl estradiol, Lebanor gestrel, and ferrous fumarate. It states that prior to starting estradiol, Lebanor gestrel, ferrous fumarate tablet, pregnancy must be ruled out. However, should the pregnancy occur while taking the tablet, so the user takes the tablet every day, but if pregnancy occurs while taking the tablet, the administration has to be withdrawn at once, right away. Okay. Now, the woman who uses this contraceptive trust pill presumably uses it because she believes that it will prevent conception, correct?
Yes, Your Honor.
Consequently, it is not likely that she would undergo testing for pregnancy every day, from day to day. That would not make sense. Huh? Do you agree? Do you agree that if you take what you believe will prevent contraception, you will not go to every day for testing?
That sounds sensible, Your Honor, yes.
Well, anyway, this insert implies that pregnancy can occur despite the use of contraceptive.
Of course, Your Honor, because contraceptives are not 100% effective.
Because continuous use, according to WHO, from what I read there, after pregnancy, well, no, not WHO, from something else. Why would the manufacturer say, when you become pregnant, don't take this anymore?
Because you don't need it anymore, Your Honor. It is a useless ceremony.
What is the new element that happened
nothing, Your Honor.
The pregnancy?
They're saying if you are now pregnant, then it failed. So stop using it because that
But
is
you will not know, no? The problem with that is you will not know.
But the all manufacturers are just erring on the side of caution. If you know, they're not requiring the user to go to the doctor every day,
WHO says
Your
that
Honor.
you will not be able to get some results from testing, at least mga 6 days or something, that you will know whether you're really pregnant. But as we know, the fertilization of the eggs takes place before signs of pregnancy. So that's the problem with this. No? A woman may decide, for now I don't want to have a baby, but I really want to have a baby. You know? So I'll take this pill because it assures me, and the doctor tells me it will prevent pregnancy. So I take it. But I did not know, that I could be pregnant. It gives me no choice that if I had become pregnant, there had been fertilization, I am not going for aborting the fertilized egg. I want to have that as my child. That's the problem.
There is no problem, Your Honor.
That's not a problem to us.
There's no problem. A contraceptive
It's not a
pill.
problem to me also because I'm not the one to have the child. But our wives, our daughters are the ones who are going to have the problem.
Our wives and daughters do not have a problem, Your Honor. Contraceptives are not 100% fail-safe. That is why there is so-called breakthrough pregnancy. It fails. If it fails, that is not the fault of anybody. The medicine is not perfect.
But
So it is not a problem, Your Honor.
That's what all this literature from this...
No, Your Honor, we respectfully disagree. All that
I don't know. We talk about realities, you know.
The reality, Your Honor, is that the pamphlet says this is good to prevent pregnancy. But if you are already pregnant, you should stop because what's the use? That is our take, Your Honor.
Well, the problem is that the law, the law itself says hormonal contraceptives. We declare that hormonal contraceptives are not abortive patients and that they should be included in this essential drugs list. You think the FDA The FDA can go to jail, no? The people can go to jail if they do not include it in the list, because it says the law itself says shall be included in the list.
No, Your Honor, they will not go to jail. In fact, the essential...
Well, you are Solicitor General, probably. But
no, Your
in the
Honor,
future...
with all due respect, as we speak, there is a national formulary. There are, as we speak, already drugs. There are already contraceptives. There is a process, Your Honor. There is a committee by the DOH. What it means, for example, is if 59 contraceptives pass, then the formulary system, how much does it cost? How are they effective? Then they will choose probably one or two. And every 6 months, they review. Because the object is government funds are going to be used for the most effective, for the most cost-effective, for the most safe.
Well,
and therefore, that system, Your Honor, is under the Generics Act. That system has been with us for since the Generics Act. For example, what is the paracetamol that is best? The formulary system will test all of the brands because they cannot say 60 paracetamols can be made into an essential. They will choose which one is the most effective but has the least cost. That's one of the primary criterion, Your Honor.
I wish what you're saying is in the law. No?
It is in the law. It is. It is in the law, Your Honor.
The issue here. The law in Section 9 says we declare contraceptives as non-abortive patient. They should be included in the drugs list, in the essential drugs list. But you are saying under the definition portion, definition of terms, FDA has control. By golly, how can we have a law like that, where the control upon the drugs is in the definition of the terms? This is for the future. I wish I said what you're saying is in the law.
It is
because
in
if
the law.
It's there, I'll not question this law.
It is in the Generics
If it is there, it's okay. But it's not there.
It is in the Generics Act
Well,
law,
anyway, that's the issue. You submit that it is there.
We will, Your Honor.
Now I'm going to ask you. The trust of the family planning that the RH law envisions is, this reproductive health is the promotion of access to all acceptable methods of family planning or contraceptives, correct? Okay.
Yes, among others, Your Honor.
Now, contraceptives that Section 9, as I said earlier, declare as unqualifiedly safe. This time I'm not referring to I'm going into the safe portion. No? You said it is we're through with abortive patient, but now you're saying also the law says that contraceptives are safe. It is an unqualified statement. It doesn't say contraceptives are safe, but it doesn't say that. It says contraceptives are safe. Now, can the RH law... No. Let me read to you Section 15 of Article 2. It says, the state shall protect and promote the right to health of the people. You get that?
Yes, Your Honor.
You cite in your comment a UN Economic and Social Council statement that says that the right to health is not to be understood as a right to be healthy. The right to health contains both freedoms and entitlements. The freedoms include the right to control one's health and body, including sexual and reproductive freedom, and the right to be free from interference. You this, this is you cite this as your own understanding of it.
Yes, Your Honor.
But this was a statement that was made by this United Nations Economic Social Council in the year 2000. It's a concept that has come around in the year 2000. Is this the meaning that the term health that the Constitution envisioned in 1986 or 87?
I believe
it did
so,
not exist yet, no?
I believe so, Your Honor.
What do you say?
I believe so, Your Honor.
You believe so, but it came out only in 2000, before, many years before this statement came out.
I cannot understand the question.
So what is your basis for believing that those who drafted the Constitution saw that the year 2000, this will be the new concept? What makes you believe that?
Because, Your Honor, what we said is an inclusive statement which for any right-minded citizen, will include health. Health is a very general statement, Your Honor.
Did the Constitution define the term safe?
I do not believe so, Your Honor.
Yes, okay. So, the only health, I'm sorry. Did the Constitution define the word health? No.
I do not, well, I am not
So the only
sure.
meaning we could give that word health, used in our Constitution, is its common meaning, right?
I believe so, Your Honor.
All right. And health, as Webster defines the term, means physical and mental well-being, freedom from disease, pain or defect. Health means normalcy of physical function. This is what the Constitution, as you said, using the common meaning, intended. Okay. So, women have the right to be free from government-sponsored sickness. Do you agree?
Absolutely, Your Honor.
Yeah, you agree or not?
Absolutely, I agree.
Okay.
The state cannot sponsor sickness.
Free from
Your
government-sponsored pain. Of course.
Absolutely, Your Honor, I
Absolutely.
agree.
Free from government-sponsored defect.
Yes, Your Honor.
Are healthy vital organs of the body part of the right to health?
I would believe so, Your Honor.
Okay. So women have the right to have normally functioning vital organs, correct?
Yes, Your Honor.
They have the right to walk in the park or in the malls in good health,
Yes, Your Honor.
free of worries of fears over contraceptives that the government has assured them is good for their health.
I do not agree. Women do not fear contraceptives, Your
I do
Honor.
not agree. Okay. Can the government...
Women do not fear contraceptives. I think that proposition is self-evident, Your Honor.
Can the government sponsor a family planning program that violates the women's right to health?
Of course not, Your Honor.
Okay. Therefore, Therefore, government-promoted and supplied contraceptives must be safe, correct?
Yes, Your Honor.
Okay. They must not expose women to the risk of harming their cervix,
Yes, Your Honor.
their breast,
Yes, Your Honor.
or their livers.
Yes, Your Honor.
They must not subject women to dangers of blood clots,
Of course, Your Honor.
pulmonary embolism,
Yes, Your Honor.
deep vein thrombosis,
Yes, Your
or
Honor.
gallbladder damage,
Yes, Your Honor.
or make them candidates for cancer and heart attacks, correct?
Yes, Your Honor.
That's good. Such government action approved and supplied contraceptives will violate, if those contraceptives will result in that would violate the women's constitutional right to health, correct?
Your Honor, the answer to that is a matter of informed choice. Because, Your Honor, what you have read are the warning labels. Some contraceptives have warning about venous thrombosis, so that is why you have progestins that I believe do not have such risk, and you have the so-called progesterones. It's a matter of informed choice, Your Honor. As the
Yeah,
court
but
said the
I was
last time, everything has those are side effects.
Kaya nga mayaman.
There are contraceptives that may cause venous thrombosis. So that is in the health warning. But you do not deny the woman the right to choose. If she wants this, because hiyang yung katawan, then there is the warning, Your Honor. But that's a matter of informed choice. Just because there is a warning doesn't mean that is government-sponsored. Every day, the FDA has to pass upon drugs that have side effects.
Well,
Justice has read side effects the other session. They are a reality of life.
well,
Unless,
I have a simple reasoning, not so complex. You said that you're a physician?
No, Your Honor, I never
You're
said that, Your Honor.
You're a doctor or something, no?
No, I never said that. What I said is I am not a doctor, Your Honor.
I'm sorry, I just thought...
Well, just for the avoidance of doubt, I am not a doctor, Your Honor.
Now, I'm just a simple-minded person. What do you say, you know? If you, a healthy organ, you know? For example, if you have healthy eyes, you can see. Do you agree?
Well,
If you have healthy eyes, you should be able to see.
you should, Your Honor.
Yes, okay. If you have healthy ears, you can hear, right? Although in my case, I have a little problem with my hearing already.
Well, it will
Right.
depend, Your Honor.
But
You might have a healthy ear, but if there's
my point is this.
if there's an interference somewhere,
Yeah. The point is the intrauterine device is plastic and metal that you plant into the woman's womb. Unfortunately, we're men, no? We don't get that into our system. But this one is a foreign body that you plant in the woman's womb. Okay? One kind is copper that kills or disables the sperm cells. I think we agreed on that. If it can kill live cells in the womb, there is no reason it will not kill live cells in the lining of the womb called endometrium. And I think even WHO concealed that it can cause atrophy now.
that's a triable question of fact, Your Honor.
Well, that is where the implantation takes place. Now, in the natural order of things, the womb is the place where the sperm will not be chemically slain, correct? In the ordinary nature of order of things, the womb is the place where the sperm will not be chemically slain, correct?
I
Ordinarily.
am not sure, Your Honor. Even ordinarily, I do not. Supposedly, from my readings,
Well, as a rule, in the natural order, of course, there can be sick women, sick with some illness, and then maybe that will slay the sperm. But in the natural order of things, for husband and wife, for example, or couples, the sperm is the place where the sperm will naturally be. All right, but here it will be. The assumption it will not be chemically slain in the ordinary order of things, correct?
I am not in a position.
And that it will be able to fertilize the ovum in the ordinary course.
In the ordinary course, I believe, Your Honor, the fertilization takes place in the
Well, in the
fallopian
ordinary
tube.
course, if you have no contraception, you are going to have pregnancy or in the ordinary course for healthy women and healthy men. That's what my point only. You agree with that?
I do not agree, Your Honor, because
So there is no, in the ordinary way, healthy men, healthy women will not conceive, will not have fertilized, will not have kids. Is that your point?
they do, Your Honor.
Hmm?
They do. In the ordinary course, healthy men and women will have kids. They do.
So don't see it. So, anyway, with IUD, and that's what the WHO says, the wombs become an unsafe place for the sperm because of the toxic substance released by the IUD that kills the sperm, correct?
I do not know if it is in the womb, Your Honor. My understanding is that the sperm is killed in the fallopian tube.
The sperm is in the
Fallopian tube.
fallopian tube?
Yes.
Well, the sperm ordinarily does not go directly to the fallopian tube. I thought it goes first naturally to the
That's why
cervix.
that to me, Your Honor, that to me is a triable question of fact. It will go back again to 4A. All of these questions
Maybe that
will
can
go
happen
back.
For an athlete male or something like that.
I don't know also, Your Honor.
Now, but with the IUD now, WHO said, among other things, that hormonal contraceptives and IUDs are safe and do not cause illness or death. That's what you say.
Yes, Your Honor.
The RH law, as I said, declared hormonal contraceptives and IUD as safe, correct?
Yes, Your Honor.
Did the law define the term hormonal contraceptives as it did the term abortive patient?
No, Your Honor.
It did not, Did it define the term intrauterine device?
No, Your Honor.
So there is nothing in the law that states the functions of hormonal contraceptives and explains why it regards this as safe. There is none.
None in the text
Now,
of the law, Your Honor.
Did the law define the term safe?
No, Your Honor.
With no definition, the law therefore did not intend the term safe to have a technical or a specific meaning. There's
Well,
no definition.
If when there is no definition, Your
Okay.
Honor, then
The
that's
term
open for the
safe,
courts.
well, in the way who will read the law, the ordinary man, will be the final referee of what is the meaning will be the dictionary, So when RH law says that contraceptives are safe, it means, according to Webster, free from damage, danger, or injury. But are contraceptives free from damage, danger, or injury?
The answer, Your Honor, is that safe is in the present FDA Act as amended and under the old FDA law. The word is safe. And safe doesn't exclude side effects, Your Honor. So safe in administrative law is just like national interest. There is no specific definition, but you let the administrative agency do its work. They are the experts. After all is said and done, they will say this drug is safe, but if you have thrombosis, ask your doctor. If you are pregnant, ask your doctor. That is the way of the FDA, Your Honor. And yet, I would say, also in the FDA Act, there is no definition of safe. Just like national interest, in the best interest, safety, public order, that's administrative law, Your Honor.
Now, according to the legislature, according to you, based its finding that contraceptives and IUDs are safe based on the WHO papers, correct?
Yes, Your Honor.
But from my reading of these WHO papers, they discuss mainly the issue of whether or not contraceptives and IUDs are abortee patients. Actually, it does not say discuss the safety features of this. Not really in that sense.
Because, Your Honor, as we said, as way back 1966, the Congress already said they are safe. That's why for the
No, I'm
past
just
15
checking out
years.
your statement that
The
this
one-
study that you attached to your comment supports the view that contraceptives are safe. And in fact, the WHO did not dwell on safety, but on the whether or not contraceptives are abortee patients. Just note that, no? I'm not quarreling with you there, no? Now, actually, the only opinion on the issue of safe nature of contraceptives that you mentioned in your comment come from the Universal Healthcare Study Group, correct?
Yes, Your Honor.
Now, tell me, have the opinions of this group been subjected to peer review of the highest quality in the field of medicine?
I am not aware, Your Honor.
You're not aware, okay. Well, if it is so, you would have been informed, since that is important for credibility of research, correct? It's credible. It will really show the top. Now, anyway,
It will
did
depend.
Congress commission, as far as you know, did Congress commission this study by the UHC group?
I do not believe so, Your Honor. I do not.
Okay,
I
so
do not believe so.
this was not an authorized study, nor did Congress supervise its conduct.
Which makes it, in my view,
They don't say that in their letter that they're
which makes, in
supervised.
my view, that they are an independent.
Spontaneous.
Independent.
Independent,
Your Honor.
okay. And now, it is a volunteer group that wants to make a stand on the issue of whether or not contraceptives are right, correct?
Yes, Your Honor.
I do not rule out the possibility. I'm not also like that, no? That the findings of this group are in error. I'm not saying that. But let us face it. Do you know if it has an international reputation, like the International Union Against Cancer or the Mayo Clinic for making scientific study on the dangers of contraceptives to reproductive health? Do you know?
I believe that each of these 24 Filipino doctors, scientists, pharmacists, pharmacologists, each on their own standing are persons that we can be proud of, Your Honor. Now,
as a
whether
group,
they measure up to the Mayo Clinic...
Their work is a group, ano? So, I'm just saying, whether this group...
But the group is composed of individuals, and there are 24, Your Honor. We should be proud of these 24.
No, I know that, but they submitted this as a group study. We don't know their individual thing. But I'm saying is there...
No, Your Honor, by the fact that each of the 24 signed...
In other words, there is none. No? There is no international, what do you call that, reputation as a group. No? Now,
I disagree, Your Honor. I believe each
show us next
have
time,
international renown, and as a group are internationally
submit an
renowned.
evidence that this is... it is that kind of reputation.
We will, Your Honor.
I gather from their declaration that you attached to your comment that the 24 experts in this study group met on August 8, 2011, and I quote, to examine raging questions on pregnancy and contraception applying scientific and evidence-based analysis. End of quotation. And drew up their conclusion, among other things, that contraceptives and IUDs are safe. Do you agree?
Yes, Your Honor.
But how could they, meeting only on August 8, make scientific and evidence-based analysis regarding whether or not contraceptives are safe?
Because each of these 24, Your Honor, are experts in their fields, and each have 60, 70 years of experience in their field. And just because they met in one day doesn't mean this is you add all the years, Your Honor. Yes, certainly they met on one day. But when they met, they brought to bear on the table all of the received experience. These are academics from UP, from all other schools,
so this is put together views, something that the individual...
Well, yes, Your Honor. Of course, how else can 24 experts
Some
put
of them are
together
not
their
even
views?
experts in... there's a variety. You said there's a lot of...
Yes, Your Honor. I can read their expertise.
Now, do you have information if the UHC group has in the past made a study like this that has been published by gold standard publications like the British or the American Medical Journal that publish only authentic and credible scientific studies? Do you have information?
I do not have as of this moment. But, Your Honor, I would also stress, why are we zeroing in on our 24?
Well, submit proof later on, if you have that information.
Can I speak, Your Honor? There is absolutely no counterpart expert group for the other side. That's my point, Your Honor.
No, but these are the standard things that...
No, that's why, Your Honor, we have 24 Filipino scientists. I'm saying the contrary view is based on what?
We all went through schools, and
no, Your Honor, on the evidence, scientific evidence submitted only to the Congress. There is none, Your Honor. Now, why pick on 24 Filipinos?
Now, have they ever made any claim to having passed competent peer review of their work?
I will ask each of them, Your Honor, to give us a bibliography of what they have written.
This particular work, not each of them.
I do not know, Your Honor, but each of them represents a learning, Your Honor. And that is not fair to ask them, but are they experts? If that question and ask, please give us the opportunity in our memo to give a bibliography of what they have written. Do they meet your gold standard? We will tell this honorable court.
Have you ever encountered a law like the RH law that declares a scientific thesis, like the one we have here, that hormonal contraceptives are safe to be unqualifiedly true, legislatively declared to be true? Have you ever found a law like that before?
Not on hormonal contraceptives, because I believe this is the first time. But the 1966 law, Your Honor, 4762, was also a congressional declaration in 1966 that they are safe, Your Honor.
Don't you think that if the government can dictate what the truth is on medical and scientific issues, and sent to jail those that disagree, we would be in deep trouble.
No, Your Honor, we are not in deep trouble.
Well, we will be if this law is declared as constitutional.
With all due respect, we will not, Your Honor.
It declares a scientific phenomenon as true.
Subject to the expert finding of the FDA. And at the proper time, Your Honor,
Based
Your
on the
Honors will have the
definition
time.
of terms. Based on the definition of terms.
Your Honor, please let the FDA do its
That's the
work. It
problem,
will
no?
go back to this honorable
No, I would have
court.
liked this law, no? If it would what you say is in this law, I would have liked it. But what you are saying is not in the another
All I am
anyway,
saying is in the law, Your Honor. FDA makes a
in
determination.
the definition of terms, according to you.
It is in the law, Your Honor. I'm not
Well,
making this up.
They put Galileo in jail for saying that the earth is round when the authorities of that era concluded that it is flat. Should the Supreme Court uphold a law that declares as correct and true one side of an issue to which experts themselves disagree?
Just because experts disagree, Your Honor, does not mean that the Congress in the executive cannot alleviate the plight of the poor by having reproductive rights, by making contraceptives universally accessible. Contraceptives which for the past 50 years are available to the wealthy.
We will be in trouble. We will be in trouble if we will trust the government with the final statement of what is true.
If Your Honors,
we will be in
please,
trouble.
the only thing that has changed is that for the past 50 years, contraceptives are available in the market for the wealthy. The only thing that changed is now the government says the government wants to subsidize access to the same contraceptives for the poor, for women, for the marginalized, for the vulnerable
I'm sorry.
in the exercise of police
I
power.
apologize
That's
for
the only
taking
change,
up your
Your
time,
Honor.
so with a reservation to ask more questions later.
Yeah. De Castro will ask questions.
I just want to go back to Section 9, where the Congress declared that hormonal contraceptives, intrauterine devices, and injectables are safe. And then we go now to the provision on Section 23 on prohibited acts. Since the law now already declares that hormonal contraceptives, etc., are safe, there is a gag order on all doctors, whether public or private, to say that these type of contraceptives are not safe. Because under the law, they will be subjected to criminal prosecution. So they cannot anymore advise their patient that they should not take this type of contraceptives because the law already declares that they are safe and they will be liable for criminal prosecution if they contradict that.
I respectfully disagree, Your Honor. I think a physician can advise his or her client that in his or her opinion, despite what the FDA says, contraceptives are not safe.
But
that's the freedom of a physician, Your Honor.
But
I don't think that is covered by the penal provision.
No, but it says here a health care service provider, whether public or private, cannot give incorrect information regarding the programs and services on reproductive health. And since the law already say that hormonal contraceptives and other devices mentioned in the law are safe, no doctor should contradict that because they will be liable for criminal prosecution. That is how I understand the law. So this is dangerous, very dangerous to all doctors.
With respect, we do not read the law to be that, Your Honor.
But that seems to be the plain
no, Your Honor,
the law.
I believe the penal provisions have to do with health workers and health physicians in government service trying to block universal access to drugs or information. Again, this will be taken up in the portion on speech in view of the conscientious objector provisions of the law, Your Honor.
That is your interpretation, but I'd like also to cite another provision of the law regarding the availability of contraceptives to minors. A doctor will also be liable for criminal prosecution if he wants to make sure that there is parental consent to the use of contraceptive by a minor. That will be the implication of the law, which penalizes anyone who will ask for a written consent
Again,
from a minor who wants access to contraceptives. Isn't that diluting parental authority?
No, Your Honor. We read it precisely to complement parental authority. Precisely that is why parental, you ask the teenager whether he or she has the consent of the parent.
But if he says yes, and since the doctor cannot require any proof, it is as if that consent is no longer necessary. That will be the implication of that provision.
With respect, Your Honor, that will be in the implementation of the law to be covered by the IRR.
You think that is nothing? There is nothing wrong with that?
No, Your Honor. With respect, not in principle.
Well, again, that's your opinion. Now, like to raise another point. Do you have any statistics on what caused maternal mortality?
I would not have, Your Honor, and with respect, that will be taken up by Senator Pia Cayetano.
Okay, so just to go ahead of that
yes, sure.
presentation by the good senator, I just want to know if maternal mortality is caused by pregnancy per se, or there are other causes.
I do not believe so, Your Honor, but without prejudice to what Senator Cayetano later will say, the RH law prevents maternal deaths. That's the purpose of the RH law.
Pregnancy causes...
No. The RH law is envisioned to prevent maternal deaths.
And it does not flow from the proposition that pregnancy itself causes maternal death?
No, Your Honor. The proposition is that if you make contraceptives universally available, especially to the poor and to the disadvantaged, then you prevent, number one, unwanted pregnancies. And if you prevent unwanted pregnancies, I think the statistics will show you also prevent maternal deaths, because there is a correlation between unplanned pregnancies and maternal deaths. That's the logic, Your Honor, as far as I can express it without the statistics.
You use the argument that we cannot generalize when we say that contraceptives are not safe. But you are also making a generalization that pregnancy is not good. And it must be prevented before it occurs. Is that the logic of your...
The proposition, what we say is the Congress would like to prevent unwanted pregnancies. Unwanted.
And how do you relate that to the health of the mother? Is it for family planning or is it for the health of the mother?
It's for the health of the mother, Your Honor.
It's for the health of the mother. Is pregnancy an illness which must be prevented?
No, Your Honor, because health is not just about illness. In fact, I agree with you. Pregnancy is not an illness.
Would you say now that it's more for family planning, as it is mentioned in Section 9, rather than for the promotion of the health of the mother?
With respect, Your Honor, no, it's not family planning. It's the health of the mother.
But that is what Section 9 says.
Section 9 says make contraceptive drugs and devices universally accessible.
Because they are effective family planning products and supplies. That is what the law says.
Because the Congress made a judgment that if you make contraceptive drugs and devices and information and services universally available, then you prevent all of these ills, unwanted pregnancies, teen pregnancies, and you thereby improve maternal health.
Pregnancy per se is not harmful to the health of a woman.
Yes, Your Honor.
That is not that, because that is a normal function of a woman.
Yes, Your Honor.
So you cannot say that the distribution of contraceptives are good to the health of a woman, because there's nothing wrong with being pregnant. If you're a healthy woman, that's part of your bodily function as a woman.
You're right, Your Honor. And the Congress recognizes that. All the Congress is saying is make these devices and drugs available and information so that women can make choices. For example, do they want a pregnancy now or they want a pregnancy later? Will they want to space their children? And so if you make information available, especially to the poor, they can say, I can get married now, but I may postpone childbearing. So that is all that the law is doing. And that's why, Your Honor, we keep saying, these contraceptives have been available for the past 50 years, but who can afford them? The wealthy. All that the RH law did is, the Congress says, we recognize maternal deaths as ills of society. How do we remedy that? Make this available so that women who are well informed may postpone marriage, have less children, and if they have less children, the women can go join the workforce. If they can join the workforce, they are more effective. There are less children to feed, there is less pressure on the economy. Now, all of these, Your Honors, are judgment calls of the Congress. They may be right or they may be wrong. What we're saying is, it is not for the court to supplant a policy decision of the Congress, and one may disagree, but the laws we have is, in areas like this, the wisdom, is this the right way to do it? The wisdom of the law, that's for the Congress, that's for the elected political branches to make, Your Honor.
We're not going into the wisdom of the law. We're looking at it in relation to the provisions of the Constitution on the right of the mother to health and the right of the unborn from the time of conception. That's how we are trying to understand this provision of the law. We're not thinking about the wisdom of the law. Now, you mentioned informed consent. No, the rich would have the advice of a OB-GYN
Yes, Your
if
Honor.
they will take contraceptives or not. What
Yes.
about the poor, whom you said are the main target of this law? The poor who cannot afford effective medical advice and contraceptive devices. But will they have that same opportunity to understand, to have that informed consent, to know what is good or bad for them?
Yes, Your Honor. That is
How do we have enough doctors in our government hospitals?
that is the principal purpose of the law, Your Honor, to enable the poor women to have access to information, Your Honor, so that if the information given is you have a menu of things that you can do, natural, contraceptive, then they can make an informed choice. And so if they say, yes, we will take this, there is the government supplied doctor, Your Honor. We may, I don't know whether we have enough doctors, maybe not. But again, the Congress is trying, Your Honor. And if we are short of doctors, the fact that we are short of doctors is not a reason not to allow the government to try its best. And with the present complement of doctors, they may not be as well paid as our gynecologists in Makati, but they will be able slowly, however, as a start, to give information so that the poor women can arrive at an informed choice.
The informed choice can only be given by a OB-GYN, because, you know, if a woman consults an OB-GYN, the doctor will get the medical history of the family of the woman, will see to it that the person is given medical blood chemistry to find out if a particular type of contraceptive is suitable to that particular woman who is to be given, or to whom a type of contraceptive is to be prescribed. Will our poor will have this type of diagnosis before they are given contraceptives?
That is the dream of the RH law, Your Honor. Make this available to the poor. Now, whether or not what is made available to them will be the same sophisticated advice that a highly paid gynecologist in Makati will give, the government, the court, we should allow the government to try. We have government doctors and they're trying their best and they are out there in the field. They may not be many, but that's the call of Congress, Your Honor.
Going now to the accessibility of the contraceptives, not only to married persons, but also to individuals. I came across during my travels to one country, I will not mention what country that is, where abortion is legal. If you are married and you want an abortion, you have it for free. But if you are unmarried, you have to pay for abortion. Here, you do not make a distinction. Whether you're married or you're an unmarried, a single person, you will be indiscriminately given access to contraceptives. Is this consistent with our moral values? Don't we? Is it? And what is the public purpose for which the government is spending money for individuals to prevent them? What I'm saying is for unmarried individuals to have access to contraceptives which are funded by the government using public funds. What public purpose will be served by that provision of the law?
The public purpose, Your Honor, is to enable all the married women, especially the poor.
The law does not apply only to married persons. It applies to individuals. As distinguished from married persons. So what is the rationale or the basis for this accessibility of contraceptives to even unmarried persons?
Because, Your Honor, an unwanted pregnancy is an unwanted pregnancy, and a maternal death is a maternal death, whether or not the woman is married or not. And so I believe the Congress recognizes that there are women who engage in the act but are not married. And so, again, this is a judgment call of the Congress. And I can argue, Your Honor, that especially perhaps with the underprivileged, the poor, the uneducated, the more that, the poor don't even bother to get married, then they have children, Your Honor. So those are ills that the Congress, I believe, should be given the leeway by this honorable court.
That not be promoting immorality?
That is arguable, Your Honor, and I believe the good senators and the good congressmen also thought of that. And as I keep saying, at the end of the day, they have to make a judgment call. Are they correct? We do not know. But did they act in grave abuse of discretion? If we grant that they are right-thinking men and they are for the good of the country, I'm sure this was debated. Does it promote promiscuity? But again, an unwanted pregnancy is an unwanted pregnancy, and these are wisdom calls, Your Honor. So I beg the Honorable Court, give the Congress the leeway.
It's not about wisdom. The Constitution mentions many times moral values that should be promoted by government. So it's not a matter of wisdom, but it's a matter of constitutional law.
Well, I believe in the calibration of whether making contraceptives available to unmarried women is a matter of call that the Congress has leeway, Your Honor.
Last question. After hearing what should I say, presentation of Justice Abad, it occurred to me that based on the report of the WHO, they are still researching on male methods of contraception. I'm raising this in connection with the substantive equality between men and women. Do you know why the pharmaceutical companies have not developed a type of contraceptive that will prevent the production of sperm?
I would not know, Your Honor.
Why is it that they have focused only on the prevention of ovulation, the prevention of production of eggs or ova? Why didn't they study also with the same vigor the possibility that if they really want to stop conception, they should also take into account the partner of the woman. And why should the woman be the one to take contraceptives every day, which some experts would say are harmful to the health of a woman?
I have no answer.
So you do not know?
I do not know, Your Honor.
Maybe all these pharmaceutical companies are dominated by male scientists. So that's.
Justice Peralta is next. I think I can venture into an answer. No male will use that. Now, we've been hearing about a lot of intrauterine devices, pills, hormonal contraceptives. In fact, my first time to hear all of this, because I'm a practitioner of abstinence. The best birth control measure, is it not, Solicitor General? Yeah.
I agree.
Okay, anyway, you mentioned about a contraceptive law sometime in 1964. Did I get you correctly?
66, Your Honor.
Yeah. Nobody questioned that law.
That's right, Your Honor.
Do you know if under the 1935 Constitution there is a provision on the population measure or population control?
I do not believe so, Your Honor.
You do not also know if there is a penal sanction for non-obedience to that contraceptive law?
There is none, Your Honor.
No penal sanction.
None, Your Honor.
So probably there was nobody who questioned the constitutionality. Anyway, there is no harm if you do not follow.
Yes, Your Honor.
I ask you this question because in the 1973 Constitution, there is a provision on population control.
Yes, Your Honor.
But in the 1987 Constitution, we do not find that similar provision.
Yes, Your Honor.
So what is now the basis of the RH bill? Is it constitutional? Because there is no counterpart provision in the 1987 that requires population measure, unlike in the 1973 Constitution. Can that not be raised now? That RH law is unconstitutional because there is no provision allowing population measure or population birth control?
Our answer, Your Honor, is the RH law is constitutional because it is an exercise of the police power of the state. The state, the government, in view of the ills of death threats, unwanted pregnancies, have come to a view that the solution is to use government funds to subsidize birth control, contraceptives, and information so that you give women the informed choice so that they don't have unwanted pregnancies, they have less children, and therefore it's an exercise of the police power, Your Honor.
But there are many issues raised.
Yes,
because
Your Honor.
the law violates the freedom of religion, no?
And
liberty.
That's one issue.
Freedom
and
of speech.
Today we tackle, yes, in constitutional law, the government can exercise police power, provided is that it does not impinge on constitutional rights. And that is why today we are here. Does it impinge on the right to life? And we hope we have persuaded the court that it does not.
Yeah, because
there will be a time when one of my colleagues will try to persuade you, does it impinge the right of religion? We will try to persuade you, it does not.
Yeah, because the nearest constitutional provision on birth control is Article 15, Section 3, Paragraph 1. This states that the right of spouses to found a family in accordance with their religious convictions and the demands of responsible parenthood. At least this is the nearest provision to that provision in the 1973 Constitution.
We agree, Your Honor. And if you will also consider, on top of that, we're trying to persuade you that a woman under the due process law has a right to liberty. And liberty, our position is, will include access to contraceptives. He has a right to privacy. And the right to privacy, which includes marital privacy, we submit includes the right to have children and not to have children, which is an echo, Your Honor, of what you have cited. We also say, Your Honor, there is a right to health. Our interpretation of the right to health is that also, whether or not to have offspring now or tomorrow or space them is covered by that right to health. We have right to health. We have also the obligations of the Philippines as a state party to international conventions, principally, notably, the CEDAW. So we will argue, Your Honor, and in the memorandum show, why these are the basis for a right of a woman to a constitutional right to have access to contraceptive drug and devices that are non-abortifacient.
I ask you also that question because I think an issue was also brought regarding the title of the law. Because the title of the law pertains to responsible parenthood. No? The title is the responsible parenthood and reproductive health. So you mix reproductive health to the responsible parenthood as found in the article of the provision of the Constitution that I just quoted a while ago.
Yes, Your Honor.
Yeah. Who will talk on the freedom of religion?
Senior State Solicitor.
Okay, I will send them my questions. Thank you very much then, Mr. Solicitor.
Thank you, Your Honor.
Justice Perez.
Just one question, Mr. Solicitor General. You have been mentioning about unwanted pregnancies. Who determines when a pregnancy is unwanted?
I will start with the woman, Your Honor. And the state also has an interest in an unwanted pregnancy. For example, a teenager still going to school.
You're not answering my question. I'm asking who determines whether a pregnancy is unwanted or not. Who says that a pregnancy is unwanted? Who determines that?
My answer, Your Honor, the woman and the state. The state has a right to determine whether a pregnancy is wanted or not, because there is an effect on the economy, Your Honor, among others.
Is the reason why the law focuses on the poor and the marginalized. In other words, I read that the law to mean that it is the poor whose pregnancies are unwanted. And therefore, as a matter of police, as an exercise of police power, you prevent unwanted pregnancies among the poor. Is that correct, Mr. Solicitor General?
No, Your Honor, not not prevent unwanted pregnancy in the poor. The statistics will show that the vulnerable, the marginalized, that's the sector where there are many unwanted pregnancies. So all the government is saying is give these people a menu from the natural planning methods to the contraceptives. And that is just state policy, Your Honor. It is not saying one is better than the other. And when we say unwanted pregnancy, I always want to say, for the avoidance of doubt, we are not talking here about abortion. Contraceptives are contraceptives.
I'm not going into that because there has already been a very lengthy discussion on whether the contraceptives that are now in the market are abortifacients. But just to follow up that question, in relation, of course, to the focus on the poor. At present, Mr. Solicitor General, does the poor or does everyone have freedom of choice insofar as contraceptives are concerned?
They have, in the sense that they can make up their mind on whether they will use it or not, but there is no freedom of choice in the sense that the poor cannot even afford to buy, or the poor do not even know what are the effects, or when should they use or not use contraceptives, Your Honor.
Are you saying that the poor are unfeeling people who do not think, who just reproduce like animals and beasts?
No, Your Honor. The Congress made a judgment that the poor are underprivileged, that they are vulnerable. And that is why the Congress decided to subsidize government money. That is what the Congress has done. They have never thought anything less of our poor brethren, Your Honor. All they're saying is they are making a finding here of social fact. They're making a finding of social fact that we have so many underprivileged in the poor, so much of the unwanted pregnancies.
And therefore they don't have the right to reproduce anymore because there are so many of them already.
The Congress is not saying that. They're just saying give money so that the underprivileged and the poor and the disadvantaged and the marginalized will be
prevent unwanted pregnancies.
Will be educated to make informed choices.
Just one observation. As it is right now, but by the way, I have not asked this question. Would you know how much a condom costs nowadays? Is that not accessible to the poor?
Again, Your Honor, I don't know the statistics on how much they cost. But again, the poor who don't even have money to buy food, I would say, it's not accessible to them.
Okay. What I'm saying is, right now, there is freedom of choice. The women can go to the drugstore and get the contraceptives that suits her purposes. You're saying that this law will enhance the freedom of choice because it can be seen as the other way around, meaning to say that when the government through this law undertakes all these programs and all these expenditures and all these projects to promote birth control or to promote contraceptives, then that program or that incentive or that a way of governance will impair the freedom of choice that presently exists. As it is now, it is an ideal situation. Everyone has a right to go into contraceptives or not. But when the government comes in and spends government money and makes an entire program about this propagation of contraception, is that not a message, especially to the poor, that you, the poor, should engage in birth control because you are causing an impediment to the progress of this country.
With all due respect, Your Honor, we believe otherwise. The Congress sees all of these ills, and their solution is make these contraceptive devices and information available, because in their view, this will alleviate an ill which the Congress sees as a real ill. And it is not to denigrate the poor, it is to help the poor.
Just a realization of the fact that the poor or poverty is a problem. You will have to accept that.
And Congress is trying to do its best to do something about it.
Without denigrating on the poor of our countrymen. Thank you, Mr.
Thank you, Your Honor.
Justice Carpio.
Counsel, you're familiar with the Millennium Development Goals.
Yes, Your Honor.
Now, there are 8 Millennium Development Goals, and all the members of the United Nations, 189 countries, adopted the Millennium Development Goals, correct?
Yes, Your Honor.
And they have agreed to adopt legislative and executive measures to accomplish those goals by 2015, correct?
Yes,
That's 2 years from now. Now, 2 of the Millennium Goals are reduction of infant mortality and reduction of maternal mortality, correct?
Yes, Your Honor.
Now, since worldwide, all countries are agreed, all governments are agreed on these goals, would you agree with me that there is a compelling state interest in the attainment of these goals?
Yes, Your Honor.
And a compelling state interest can prevail over religious beliefs, correct?
Yes, Your Honor.
Okay. Now, let me go again to some other basic points. We presume every law to be constitutional, correct?
Yes, Your Honor.
And because we have that presumption, anybody who questions the constitutionality of a law must point to a specific provision that is being violated, correct?
Yes, Your Honor.
That means you cannot question the constitutionality of a law hypothetically. You cannot speculate, correct? The general rule.
Yes, Your Honor.
And we have the exception, a very narrow exception. You can facially attack the constitutionality of a law under what conditions? One of the conditions is you have to prove that under all circumstances the law will be unconstitutional, correct?
Yes.
That's one of the conditions. Under all or nearly all circumstances or set of facts, the law will be unconstitutional. That is one of the conditions to facially attack a law, correct?
Yes, Your Honor.
Now, we go to the RH law. You have a menu of devices, drugs, contraceptives to prevent fertilization. Now, under the theory of all of the parties here, our petitioners are mounting a facial attack, correct?
Yes, Your
This is a facial attack. And so the burden of the petitioners will be very high because they have to overcome the presumption of constitutionality and they have to prove that under all circumstances the law will be unconstitutional.
Yes,
Okay.
Your Honor.
So you have a menu of contraceptives from the IUD to the condom to the hormonal contraceptives. Okay. If you use condom, definitely it will not violate RH law, correct? Everybody is agreed. There is no violation.
Yes, Your Honor.
If you use vasectomy, I don't think anybody can mount a facial challenge, correct?
Yes.
There are other methods, like the heat method. You know the heat method?
No, Your Honor. I'm sorry, Your Honor.
The heat method is if the temperature of the sperm exceeds 35 degrees Celsius, the sperm will not be able to fertilize the ovum. So you apply that on the male. You hit the balls of the male. Okay, and you have the ultrasound method. What is the ultrasound method?
I am not familiar.
The same thing. You put the ultrasound on the organ that generates the sperm, and that will work the same way. The temperature will rise, and the sperm will not be able to fertilize. So there are contraceptives that are applied to the male. You have heard of the Vasal gel, which is now on third phase clinical trials, and they plan to release it by 2015. It's a male contraceptive. So you will not have a problem of possibly committing abortion because the contraceptive is in the male. So you have a situation here where there are a lot of situations where the law can surely be constitutional. You cannot question condom, vasectomy, and others. So would you agree with me that a facial attack on this law requires the petitioners to prove to us that under all circumstances, under all sets of facts, there is a possibility of an abortion?
Yes, Your Honor.
Because that is their point. Okay. So that is a very high bar, because the petitioners could have gone to FDA and questioned particular drugs. But you have mounted, the petitioners have mounted a facial attack, and the bar is very high. Okay, let us go to Section 9. It says that the national drug formulary shall include hormonal contraceptives, intrauterine devices, injectables, and other safe, legal, and non-abortifacient and effective family planning products. So, Section 9 says the hormonal contraceptive must be safe, legal, and non-abortifacient. And who will determine this under Section 4A?
The FDA, Your Honor.
The FDA, because under Section 4A, it is the FDA that will determine whether it's an abortifacient or not.
Yes, Your Honor.
So you have to interpret Section 9 in relation to Section 4A and to the general powers of FDA to determine before the drug can be allowed to be sold, they have to determine that it is safe. Correct?
Yes, Your Honor.
Okay, thank you, Counsel. That's all.
Justice Del Castillo.
Just one question, Counsel. The RH law allows the availability of these contraceptives provided they will not be used as an abortifacient.
Yes, Your Honor.
So there's a possibility that these contraceptives, these drugs and devices may be used as an abortifacient?
No, Your Honor. There will not be a possibility after you have the FDA certifying that.
Yes, but why does the law still says that provided that they will not be used as an abortifacient?
The context of that, Your Honor, is that there are certain drugs which are abortifacients.
So how can the government make sure that these drugs will not be used as an abortifacient?
To the best of my understanding, Your Honor, for example, a woman who is pregnant and then the doctor says there is no more fetal heartbeat, then the unborn or the fetus is dead. The doctor will have to induce abortion. Sometimes you do this by cataracts, which I think incision, but many times there are drugs that are abortifacient. They are life-saving because then you bring the woman to a health center, the baby is dead, you induce abortion. The doctors can correct me, one such drug I think is called oxytocin. So any hospital has oxytocin in its pharmacy because you need that as a life-saving drug. That is the context of that provision which says should not be used as an abortifacient. Meaning, just like restricted drugs, oxytocin will only be used in a hospital to be used for therapeutic abortion. That, I believe, Your Honor, is the meaning of that cannot be used as an abortifacient. Meaning, the National Drug Formulary contains oxytocin, I believe, today. But that is to be used under certain very, very restrictive conditions. That's the meaning of should not be used as an abortifacient. Meaning, a woman who is healthy in the pregnancy cannot go to a doctor and the doctor will say, oh, do you want an abortion? I'll give you oxytocin. That cannot be done, Your Honor. That's my understanding.
So when there's only a choice between the life of the mother and the life of the child?
That's my understanding. The best example is the monitor shows there is no more fetal heartbeat. If you don't induce abortion, the mother will die.
Thank you, Counsel.
Justice Mendoza.
Just a few clarificatory questions. Earlier, you referred to Section 4A, the definition of abortifacient, that any drug or device that prevents the fertilized ovum to reach and be implanted in the mother's womb. You mentioned from the fertilization takes about 7 days. You cannot use an abortifacient. Am I correct?
Yes, Your Honor.
When you say that the use of abortifacient is prohibited before implantation, do you agree with me that a fertilized ovum already has life?
That is the extent of the protection of the state, Your Honor.
It has life.
4A says from the 4A says from the time there is fertilized ovum, state will protect.
It has life. Do you agree?
That one can arrive at that conclusion, Your Honor.
I see, because in the Constitution, it is provided that life begins from conception. Now, what was the intent of the framers regarding this matter, when life begins?
With respect, Your Honor, we say,
for the record only,
the Constitution says the state must protect the life of the unborn.
Yes.
It doesn't say when does life begin.
No, I was asking about the framers, the intent of the framers.
We believe, the government believes that the intent of the framers is to prohibit a Roe versus Wade type of decision from any court, or the legalization of a Roe versus Wade type abortion by the Congress.
But did not the framers mention about when life begins?
That was much debated, Your Honor. And that is why...
But that was adopted by the Constitutional Commission.
Well, again...
And then ratified by the people.
Yes, again, Your Honor, what was adopted and what was ratified by the people is the state must protect the life of the unborn from conception.
That is clear. That is clear. Now, we go to another point. The Magna Carta of Women amply provides for the health of women, including reproductive health. Why is there a need for this reproductive health law?
Two reasons, Your Honor. The Magna Carta talks about rights, but it doesn't give implementing provisions like the subsidy. The subsidy now to be given so that women can exercise informed choice. Number two, the RH law clarifies that contraceptives, provided they are legal, safe, effective, non-abortifacient, are among the menu of drugs or devices that can be given. So the position of the government is where the Magna Carta ends, the subsidy comes in. That is why you need an RH law. Otherwise, the Magna Carta is all about rights. But if you don't give them the subsidy, then again, the poor, the disadvantaged, the marginalized will not be able to exercise their rights.
Under Section 17 of the Magna Carta of Women, speak of rights. Now, it says that there is the comprehensive health must give due respect to the women's religious convictions or and the rights of the spouses. This too does not appear in the RH law.
We believe it implicitly is there, Your Honor, because RH law is all about informed choice. Nobody is forced to accept, adopt any device, any information that one doesn't want to. It is a subsidy, as we said in our comment, to the willing. The unwilling are free, not to participate, or receive the subsidy of the government.
Oh, Section 17 also speaks of the rights of the spouses. It appears in the RH law that the husband, I think, is not given, his views are not heard. The one undergoing the procedure, her opinion prevails.
We believe our reading, Your Honor, is the husband is heard.
Still?
Still.
But if there is a conflict?
Well, the law says if there's a conflict, since the woman is the one who is going to bear the children, then the law steps in and say, load the decision making in favor of the woman.
But does not the father have also the right regarding the viability of
I believe so, Your Honor. Every father should be part of the conversation, should be part of the decision.
No, in case of conflict.
Again, in case of conflict, the Congress has weighed in. And in a proper case, a husband can go to this court and say, I want equal rights. But we are not yet there, Your Honor.
In case of an emergency, a woman has that, the view of the mother prevails under the RH law. Suppose there is no emergency, it's just to do away with the unwanted pregnancy.
If there is no emergency, Your Honor.
No emergency. There is no threat to life. She does not want...
If there is, I'm trying to understand, like, if there is no threat of life, then there is no need to balance, Your Honor.
The mother does not want to proceed with the... Anyway, that will be an abortion already, no?
Yes, Your
Because
Honor.
there is already life.
The Congress is very clear. No abortion.
Yes. That's our chief.
Thank you, Justice Mendoza. Justice Bernabe first.
Counsel, I read in a medical journal that IUDs are not meant for women if they have not given birth to at least a child, have breast cancer history, or have had multiple sexual partners. Now, I just want to know what safeguards are put in place to prevent the use of IUDs by women who are not meant to use this family planning method.
I am not familiar if there would be warning in the literature, Your Honor, and that's one way. But I think at the end of the day, all of those concerns will be paid attention to by the doctor or the health worker.
Now, do you think the poor and the uneducated will have the capacity to make an informed decision, or will they just heed the advice of the professional or the skilled worker?
They would of course, at the end of the day, make their own decision. But with the theory of the Congress is with the help of well-meaning and in good faith health workers, a menu of things available for them, and hopefully they can make the right informed decisions. You know.
Considering that they are uneducated, would their consent be impaired, or at least the right to effectively use these contraceptives, or the right to consent will be impaired?
You are right, Your Honor, but I think the way we read the Congress is they are spending government money on the faith that our poor, if things are explained to them correctly, are going to make the right decisions.
Now, since you have defined the right to health as one, including the right to control one's health and body, including sexual and reproductive freedom, don't you think that with this lack of consent or with this impairment, then they would effectively be deprived of the right to health at the end?
I would not believe so, Your Honor. I respectfully disagree. The judgment of the Congress is you help the poor and you trust the poor precisely so they make informed judgments. Whether some of them may end up not making the correct judgments has got to do with the wisdom of the law, Your Honor. But theoretically, you might be right. But I think, again, these are difficult decisions to make, Your Honor. That is why we have a Congress. These are judgment calls they make every day. These are painful decisions. Whether they subsidize to the tune of X amount or they do this, as was said a while in weeks ago, why don't we spend all of this money on education? Because if we educate everybody, then there will be no poor. If there is no poor, then there will be no underprivileged. But the Congress is looking at all of these ills which happen all at the same time. So they give some for education, they give some for the subsidy, as they have to spend for national defense, as they have to spend for public safety and order, Your Honor. So, yes, you might be right, but these are painful decisions made. These may not be perfect decisions, but let the Congress try. It is not, all we're saying is, they are trying, and the test of this honorable court is the Congress correct, but whether is the Congress acting in grave abuse of discretion, Your Honor.
Now, you admitted in your arguments that contraceptives have side effects and adverse reactions. Now, would you consider the risk of adverse reactions higher on the users afflicted with ailments?
No, Your Honor. I think the statistics are that the risks of contraception are far, far lower than the risks of a pregnancy. Meaning, when one gets to be pregnant, there are more risks attendant to being pregnant than to using contraceptives. And I don't have the statistics now, but we will present it through Senator Cayetano, Your Honor.
Now, just one final question. Would you agree that for the safety of prospective contraceptive users, there is a need to check or determine one's medical history first?
Yes, Your Honor.
And how would this be addressed in the law?
Just like what the wealthy now do, Your Honor. I believe all of the literature shown to this court invariably contain a notation, consult your doctor first. So, should you validate, when you validate the RH law, there is an obligation, again, of the government doctor and the government health worker, I believe automatically, to make sure that before a woman takes a certain type of contraceptive, that she is not open to the type of side effects. That's why I'm saying, Your Honor, I believe that's why there are different formulations, because there are contraceptives that have side effects on thrombosis, I believe. There are those, that is why there is the so-called progestin only. Their side effects are different on different women. It is up to the doctor to choose. But no, I believe no contraceptive, and for that matter, no drug is without side effects. And so again, that's the regime that we have of the FDA. When the law says safe, pure, effective, safe means within the best knowledge of science. We will tell you this is effective, but watch out. And under the law, the obligation is you, manufacturer, print the warning so that the doctor will pay heed.
Okay. Thank you, Counsel.
Thank you, Your Honor.
Justice Leonel.
Good evening, Counsel. May I ask a bit more of your indulgence for a few more questions? Maybe I should shift ground a little and look at the core values. After all, you and I have been professors in a very good school, very good law school, in constitutional law.
I agree, Your Honor.
Perfectly. And I'm sure several others would agree. That the counter-majoritarian power of this court is only with respect to whether there are core values that are embedded in our system, in the words of our Constitution, that we need to protect. Is that not correct?
Yes, Your Honor.
Yes. And therefore, again, your indulgence as I go through some of the principles, in order just to get my mind at least clear on the direction of this particular piece of legislation. So first, may I ask you, are there Filipinos who do not eat 3 meals a day?
I believe so, Your Honor.
As a matter of fact, there are people that can go hungry on a daily basis.
Yes, Your Honor.
Not having any square meal.
Yes, Your
for that matter. And many of them, of course, may not be in the streets of Metro Manila, although there are some, but many are in the mountains, in the rural areas, and may not be present here, may not see the live tweets coming out of this courtroom. Are we not correct?
Yes, Your Honor.
Yes. These people, do they have education? They do not have access to education, precisely, maybe a cause, or also an effect of the fact of their poverty. Is that not correct?
Yes, Your Honor.
Yes. And in many instances, even the church may have no access to them. Is that not correct?
Yes, Your Honor.
Because the nearest church may be kilometers away, and they will have to make a very strong moral sacrifice for them to actually attend Sunday masses for Catholics, or Friday prayers for the Muslim, and many others. Is that not correct?
Yes, Your Honor.
And for them, government probably is not even in their imagination, and to them, government as a reality may not exist. Is that not correct?
Yes, Your Honor.
Of course, we do not want that situation.
Yes, Your Honor.
There are males and females in these kinds of families. Is that not true?
Yes, Your Honor.
And correct me if I'm wrong, they cannot get pregnant.
The males cannot, Your Honor.
They cannot. The females, I mean, of course the males cannot get pregnant. But the females in these kinds of situation, do they get pregnant?
Yes.
You mean to say, even if they do not have 3 square meals a day, no education, no access to the church, they can still get pregnant?
Yes, Your Honor.
Why?
Arguably, number one, because they don't have education.
And because sex is an instinct,
it's
right?
An instinct, Your Honor.
And as a matter of fact, we know that in constitutional law, this is a marginal area. When we start to talk about sex and intimacy and the powers of government within this field, it is really a very, shall we say, ambiguous territory that we go into. So the fact is that they do get pregnant. Is that not correct?
Yes, Your Honor.
Just to go straight to one point. Is this law a law that encourages promiscuity?
No, Your Honor.
Is this a law that encourages sex? As a matter of fact, do you need law to encourage sex?
No, Your Honor.
I take your word for that. But in any case, so this is not a law that encourages sex or promiscuity. But still, sex happens among the poor and the rich. Is that not correct?
Yes, Your Honor.
But why is it that the fertility rates of the rich is lower than the fertility rates of the poor? In other words, if I may try to understand it from a lay perspective, that the number of children per capita of those who are considered poor are bigger are larger or more, than the people who are rich. Why is this, counsel?
Possibly because those who are wealthy have more education, and because they're educated, they want to space their children, and they want their children to have the best, so they don't have to have as many children, Your Honor.
The people who are rich and are catching time, etc., do not have the time. They work 8 hours a day. If they were a justice of the Supreme Court, they would be working, 25 hours a day, etc. If they were Solicitor General, more than that. So they will not have time to do these kinds of activities. Is that not correct?
Yes, Your Honor.
Well, I hope that some of us can have some time for that. But in any case, so the point is that there is time. Also, that they know the consequences. Is that not correct?
Yes, Your Honor.
And the consequences have something to do with their financial status, etc.
Yes, Your Honor.
But how come, on the part of those who are poor, that these are not a consideration? First, that they have time on their hands. Second, that they do not see it as something that will burden them. Instead, they see it as something that will help them. Why is this, counsel?
Probably because of some of the ill-informed conclusions. Will that be when you have more children, for example, the poor, then there are more helping hands. But then, there are more mouths to feed, Your Honor.
The truth is that some do not know better. That can be a possibility.
It can be, Your Honor.
Can also be that they know that a large number of children increases the probability that one of them may be able to go to the UP College of Law as a state university, make it as a lawyer, join the Solicitor General's office, become a bit richer, etc., and therefore be able to plow back some of the wealth back to the family and get them out of poverty. Is that
yes,
not
Your
correct?
Honor.
So there are lots of reasons why they will have sex, they will have children, etc. Let me go to another point now that I want to make. Why is it that we just don't maybe say that sex is unconstitutional? Sex outside marriage is unconstitutional. By the way, is it illegal to have sex outside marriage?
I don't believe under the revised penal code, Your Honor.
So long as they are adults, to be very clear.
Yes, Your Honor.
So why don't we go directly to that point? Why can't we not simply outlaw the act itself?
That will collide with among others, constitutional right to liberty.
Liberty, and we will be controlling,
privacy.
Most importantly, women's bodies.
Yes.
We would go into privacy questions, and I think most important of all, that kind of law cannot be implemented.
I agree,
because
Your
it will be impractical. Is that not correct?
Yes, it will involve the government getting into the privacy of the bedrooms or the.
So definitely, it is not the avenue. So we are saying, are you saying, counsel, that this law was not to encourage promiscuity?
Yes,
it is
Your
not to
Honor.
outlaw sex. It is not to impose a morality. But
Agreed.
can we say that this law acknowledges a reality that there may be those people who are not as fortunate as you and I that need more information, that need more assistance in order to buy, as one justice would say, a condom or any kind of contraceptive that is not an abortifacient in order to be able to assist them.
I
Is that
agree,
not
Your
correct?
Honor.
Yes. And of course, there are, shall we say, side effects to this law. That incidentally, perhaps, some people might abuse the possibility that there are this information and go morally wayward because the church do not teach them properly or the family do not teach them properly. Is that not correct?
That's correct.
Yes, but that is not the lookout of the Congress. Is that not correct?
That's correct. Your
Yes,
Honor.
the Congress has to act on something, a problem, but you cannot expect it to have a solution that is perfect. Because there is no such thing as perfection in this world.
We agree,
Is that
Your
not
Honor.
correct? And therefore, there are laws that will have some bad effects, and there are laws that, but considering the good effect of a particular law upon the judgment of Congress, then therefore they pass a particular piece of legislation. Is that not correct?
Yes, Your Honor.
By the way, counsel, is that not true also with any kind of technology?
Yes, Your Honor.
That there are good and bad sides, correct?
Yes, Your Honor.
The iPad is good to put in our information, but it is also bad because it tempts all of us to go to games, I'm not sure, Facebook, Twitter, etc., and lose our focus on what we have. Paracetamol, as we read earlier, has side effects. So does an IUD or even a condom, perhaps, can have a side effect and may not result to something which it is intended. Is that not correct?
We agree, Your Honor.
Yes. So therefore, we have to grant a particular agency in government that right to make a mistake. Is that not true?
Yes, Your Honor.
And for so long as that mistake has been tempered, in other words, made as a political decision, and does not infringe upon the core values that are contained in the Constitution, this court, as you said, must stay its hand. Is that your position?
Yes, Your Honor.
Yes. And in this particular case, yes, we are touching upon very raw nerves: life, sex, intimacy, morality. Still and all, our benchmark, our framework, should be from the point of view of our secular constitution. Is that not correct?
Yes, Your Honor.
We have to suspend our moral judgments in order to be able to see whether there is a compelling secular interest, as Justice Carpio would call it, a compelling secular interest that the Congress had the right to promulgate. Is that not correct?
Yes, Your Honor.
After all, counsel, it is not too late, because since these are facial challenges, there can be an actual case later on that can come up to this court, and this will not be res judicata, or will it be, counsel?
It will not be res
judicata. It will not be res judicata, because now it is only a facial challenge. A while ago, there was a slide which said how to prevent a child being born, something like that. Is that not correct?
Yes, Your
The
Honor.
3 points. May I add one more point, if you will agree with me, that being a bachelor can result to not having a child?
Yes, Your Honor.
Oh, not necessarily.
Also, Your Honor.
Yes, celibacy, for that matter, or abstinence, as one justice would say it. Is that not correct?
Yes, Your Honor.
Or some people try, but for reasons only God will know, they cannot have children. Is that not correct?
Yes, Your Honor.
Yes. So in any case, there are many reasons why you cannot have a child.
Yes, Your Honor.
Yes. It is not only because that act or that event is an abortifacient. Is that not correct?
Yes, Your Honor.
Yes. Can I go to another point, just to move on quickly? Constitutional interpretation. There is originalism. Is that not right?
Yes, Your Honor.
It's a modality that is accepted, but it is not universal, and it is not foolproof. Is that not correct?
Yes, Your Honor.
Because in originalism, we assume that the people ratified the words in the Constitution knowing the meanings that were in the minds of the framers of the Constitution. Is that not correct?
Yes, Your Honor.
And therefore, there are legitimate constitutional theories which say that originalism is not true or should not be the modality.
Yes, Your Honor.
There is also the interpretative mode of contemporary construction, looking at what the words mean to people today. And I think that is your theory in terms of your initial presentation, that the political departments have as much right to read the Constitution, provided that the words can be borne by the meaning that they impose on it. Is that not correct?
Yes, Your Honor.
Yes, and that too is legitimate.
Yes, Your Honor.
And also on the part of the court, we can look at the context of the words in the Constitution, such as, for instance, Article 3, Section 1.
Yes.
No person shall be deprived of life, liberty, or property without due process of law, correct?
Yes, Your Honor.
But on the other hand, we look at Article 2. Article 2 does not use the word life only once. There are many other provisions in Article 2 of our Constitution which actually provides for life.
Yes,
I mentioned, for instance, Section 5, where it says, the maintenance of peace, order, the protection of life, liberty, and property, and the promotion of general welfare are essential to democracy. It balances life, the right to life, with all the other necessities such as general welfare, etc. And there are a few more, like Section 11. The state values the dignity of every human person and guarantees full respect for human rights. This includes a person, a female, who cannot eat 3 meals a day, but has to bear children simply because she doesn't know any better. Is that not correct?
Yes, Your Honor.
Yes. And there is Section 17 of the Constitution, which actually says that the state shall give priority to education, science, etc., and then at the last clause, and promote total human liberation and development. So, in other words, as again another justice mentioned, the Constitution is not passive about life. It does not simply prevent the government from touching it. It requires government to have to instill a quality of life. In fact, if I am not mistaken, it is also provided in the Constitution in Article 2, Section 9, that one of the goals of the state is an improved quality of life for all, or to read the entire phrase, a rising standard of living and an improved quality of life for all. Do you see that in your Constitution,
Yes,
Council? So therefore, it is not only the prevention of the touching of life as we imagine it, but that the state has also a role or a duty to improve the quality of life of everyone. Is that not correct?
Yes, Your Honor.
Yes. Just a few technical issues. The 1966 law that you mentioned, it was not challenged under the 1935 Constitution. Is that not correct?
Yes, Your Honor.
Probably because, as one justice mentioned, there is no provision there on the right to life as we have it here in the 87 Constitution.
Yes, Your Honor.
But do you know, has it been challenged under the 1987 Constitution?
I believe not also.
And 1987 is about 40 years...
26
years ago, and it has not likewise been challenged. So, again, Counsel, is it a fair assessment to see this law as providing for informed consent?
Yes, Your Honor.
Is there any coercion?
No, Your Honor. There's
It's like providing all the menu of options in order that there can be a choice of the couple based upon the religious conviction to space their children. Is that not correct?
Yes, Your Honor.
And spacing children, I believe, is in Catholic doctrine as well as in Islamic doctrine. Is that not correct?
I believe so.
Yes. It is like pork, made available to the public, but because of the strength of a religion, people who believe in Islam do not eat pork or do not drink wine. But it is available, freely available. And in fact, government has an agency that actually checks the quality of pork. Is that not correct?
Yes, Your Honor.
Yes. And what we have here is simply a government initiative to allow the FDA to check the viability of contraceptives in order to be able to assure itself that it is safe and non-abortifacient. Is that not correct?
Yes, Your Honor.
Yes. There is a problem with Section 9 as some of us see it. It says intrauterine devices and other safe, therefore creating an initial impression that all intrauterine devices and all hormonal contraceptives are already determined by the law as safe. Is this a fair reading of the law?
Well, you have to read it in relation, Your Honor, with 4A.
Which is that it must not be an abortifacient. Therefore, are we saying that there are contraceptives that can be abortifacient?
There could be, depending on the finding of fact of FDA.
And we are also saying that there are contraceptives which will not be an abortifacient, provided that it is used in the proper way.
Yes, depending again on the FDA's finding.
The FDA normally says there are indications or there are ways by which a drug must be ingested. Is that not correct?
Yes, Your Honor.
Therefore, can we conclude that all drugs can actually kill people, or there are drugs which can actually kill people if not used properly?
Yes, Your Honor.
Like, for instance, Bisolvon, a cough syrup, can be, addictive. And so on and so forth. Rugby, I think, is used by some. So, in short, counsel, does this law, therefore, from your point of view, enhance the right to life?
Yes, sure.
Or does it prevent the life, quality of life from happening?
It improves the quality of life.
Is it fair for us to doubt whether it will work or not work?
We should.
I guess we should. But the point is, should our presumption be to allow this to be implemented because the political organs made the judgment, absent again any clear showing that it does violate clear textual provision in our Constitution?
We will try to persuade your honors that there is no violation of any textual provision.
Thank you.
Thank you, Your Honor.
Justice Abad.
I think the point is that under Section 9, the legislature declared hormonal contraceptives, intrauterine devices, injectories, and others as safe and non-abortive patient. And I think your explanation is that, well, this is in a way qualified by Section 4A, which subjects all these things to review by the FDA, correct?
Yes, Your Honor.
So the FDA, under Section 4A, will determine whether the contraceptive is safe or abortive patient.
Yes, Your Honor.
But I'd like to read to you Section 4A. What it says is that, if you have a copy,
Yes, Your Honor.
definition of terms for the purpose of this act, the following terms shall be defined. This is actually definition of terms. You know? A, abortive patient refers to any drug or device that induces abortion or destruction by fetus inside the mother's womb, or the prevention of the fertilized ovum to reach and be implanted in the mother's womb upon determination by the FDA. And this is what you said. But I thought you said that this Section A empowers the FDA to determine two things: that the contraceptive is safe and that it is non-abortive patient. Show me, where in this definition does it say that the FDA will determine safe?
It's not in this provision, Your Honor. It is in the general charter of the FDA. And they are
it's not accurate. You're saying that you find the power of the FDA to determine safety. Well, because the law itself says, let me finish. The law itself says, this is safe, non-abortive patient. Therefore, our command is that it be included in the essential drugs list. So, do you think anybody can do that if the law itself mandates its inclusion in this essential drugs list? Can anybody violate that statement that it is safe and it is non-abortive patient, therefore it should go into the essential drug list? Somebody can question that?
Of course, Your Honor. Somebody can question.
But that is the law. I thought it's binding even to us.
Yes, Your Honor. But the FDA is an administrative agency.
Yes, but the FDA is only abortive patient. Your Section 4A mentions only abortive patient. Nothing about the safety features of the contraceptives.
Because, Your Honor...
No, that's all. That's all. You write memorandum.
Can I finish, Your Honor? Because under the general charter of the FDA, safety, purity, efficacy. Now, the RH law adds that in the case of contraceptive drugs and devices, IUD, you add the 4A. So the FDA charter is pari materia, is legislation pari materia to the RH law.
No, you will bring me to another point.
There is no need to reproduce the whole charter of the FDA on safety into the RH law. Otherwise, every time, you will have long and very long laws if you have to reproduce the general charter of the FDA. The meaning of upon determination of the FDA is it brings in, upon determination of the FDA is a term of art. You bring in all of the law about the FDA. And certainly, anybody who disagrees with the FDA, there is an administrative procedure to bring it up to the Court of Appeals and ultimately to this honorable court. You will have a second pass, Your Honor, if you believe that they are in grave abuse of discretion.
Well,
that is our law, Your Honor. This court is not a trier of facts, especially not of scientific facts.
Yes, but the court can take judicial notice of treatises and authorities. And I'm going to read to you from these treatises. And what does it say? It says here from the WHO, the International Agency for Research on Cancer. They say, previously combined oral contraceptives that you say is safe had been determined to be carcinogenic to humans, to our daughters and our wives, but only primary liver cancer was specified before, implicated. The working groups concluded that combined oral contraceptives after the risk of several common cancers in women. They increase a woman's risk of cervical cancer, breast cancer, and liver cancer. At the same time, they have protective effect against endometrial cancer and ovarian cancer. That's the only thing that's safe. And mind you, contraceptives is not technically what the FDA is doing before, medicine. Medicine is for the cure of illness. They have parameters that are addressed to medicine that cures illness. You balance a particular medicine against its side effects because you save him from dying, although there will be some effects upon his organ, but the fact is it's so important because he will die. But here, no. It's a different thing. That's why I'm looking for some standards, because here, he wants this risk, so he will have the pleasure of sex without responsibility. Yeah. In exchange, that is the exchange, no? It's not the same exchange in drugs, in medicine. In medicine, you say, you take this medicine, this is against this kind of illness, heart attack. Although your liver may suffer a little, but if you don't take this, you'll have a heart attack, you'll die. There's a balance, the law balance. But where is the law? It's not the same, no? That's what I'm looking for. I like this law, provided that it has what you're talking about. It does not have that precaution that says, you see that the balance is clear. The balance is, the law makes the standard clear for the agencies to decide whether it is safe enough to be placed in the marketplace so people can accept the risk against the pleasure that they desire. So, ibang exchange dito, hindi illness. There is none. Another point, you say you punish 1 year and 1 to 6 years the persons who say this is unsafe, when you say that the government's position is that it is safe. And then he will go to jail for 1 or 6 years. But you do not punish in this law those who manufacture drugs that have abortive patient. That's what I'm looking for. That will deter manufacturers from marketing in the Philippines drugs that have abortive patient function. There's a lot of things we're looking for. And the other point that we are looking for also here, these drugs are for the poor in the slum areas, the millions of poor. They don't have money for fare. And what does this about this literature tell me? It tells me that before you take these drugs, you should go to a physician, have some tests. It says there, have some tests against the possibilities of the side effects. And it also says there, you should have regular check-up. This is targeted to millions who have not even money for fare. So where is that? I'm looking for, and then, are we protected against manufacturers that make misrepresentation? In the U.S., Bayer was sued in several states, and it is set aside $1 billion to settle for these settlements. Does our law that you say protects our people provide for remedies against manufacturers? In Thailand, in Karachi, and in India? Oh, none. I'm looking for that.
You cannot find it in this law, Your Honor. It is in the Consumer Act. Again, another legislation that is in pari materia. Now, but if I believe the Congress hears you loud and clear. Would you want a law that will punish manufacturers who manufacture abortifacient? The Congress will come up with that law, and then they hear you loud.
It is not in your law. That's the problem.
But, Your Honor, the essence of the ability of the Congress to try to alleviate some ills is that it doesn't have to be perfect.
Alleviate, but endanger their lives also.
We respectfully disagree, Your Honor.
But it says here, if you feel any pain, go to a doctor.
And they will go to the...
You think, have you prepared for that? Have you prepared for the teeming millions of poor to be able to, you give them these drugs and you think our problems are solved?
That is what the RH law is all about, Your Honor. The bureaucracy
that is one point here, no? Your target is the poor.
The beneficiaries.
So that they will not produce. You know, in the time of Hitler, their target were the Jews. So there will be less production of Jews. Here, the target is the community of the poor.
The government.
And you want them to reduce their rank.
The government.
They are very uncomfortable. They are inconvenient to us. You know?
And the government.
The poor is an inconvenience to us. We want to eliminate their volume, their size.
And
so we give them these abortive patients without the safety protection that I'm looking for. You give it.
And the government.
This law is okay if you protect the poor.
And the government, Your Honor, the Congress, the Senate, and the Executive Department takes very strong exception to the illusions about Hitler. This government, this Congress is pro-poor. We are not pro-Hitler.
Pro-poor, that's why you're giving them contraceptives. That according
we
to
can
the
disagree, Your Honor,
WHO itself,
we take strong exception.
Cancer.
Your Honor, when it suits Your Honor, you quote the WHO. But when it doesn't suit you, you attack the WHO. Now, how?
Thank you.
Thank you, Your Honor.
Okay. Justice Carpio will ask the last set of questions.
Yeah, I just have one question, Counsel. Section 24 on penalties. It says any violation of this act or commission of the foregoing prohibited acts shall be penalized by imprisonment, so on. So any violation of this act or of any provision of Section 23 shall be penalized by imprisonment, correct?
Yes, Your Honor.
Because the prohibited acts are those mentioned in Section 23. My problem, Counsel, is if you go to Section 7, it says, all accredited public health facilities shall provide a full range of modern family planning methods. So if an accredited public health facility, like a hospital, cannot provide the full range of modern family planning methods because they don't have the money in the meantime, then they will now be penalized by imprisonment, and their officers will suffer for that. So isn't that too overbroad, Counsel? The phrase, any violation of this act. I have no problem with any violation of the foregoing prohibited acts in Section 23. My problem is when you say any violation of any provision of this act, you have so many provisions here which says this party shall provide a full range. The government shall guarantee a family, a minimum family wage. Who will be penalized and how can you penalize? So would you agree with me that this is too overbroad, the phrase, any violation of this act? The rest can be sustained because very specific, only Section 23.
We respectfully argue, Your Honor, that Section 7 is not a specific target of a prohibited act. But we agree with you that in that sense, it is overbroad. But in the interpretation, Your Honor, this Honorable Court has always interpreted laws to have effect. And the example is it's commonplace, I would submit, that many of the laws we have will have a penal provision which says for any violation of this act. For example, the Corporation Code. But in actual practice, Your Honor, when there is a prosecution based on any provision of the act, then, you know, this court will have, as the court of last resort, still have the opportunity to make sure that overbroad provisions
because one of the issues raised by petitioners is they're afraid now because any violation of any provision here will be covered by a penalty, imprisonment
We understand, Your Honor.
Okay, that's all, Counsel.
We'll cover that in our memoranda.
Thank you.
There being no further question or comment from any of my colleagues, the session is hereby adjourned to resume next Tuesday, same time, same venue.
Please remain in your respective seats until the Chief Justice and the Associate Justices leave the session hall.